I may be pardoned to mention.
Criminal appeal. When a taken in custody for more than 9 years. More than 9 years in custody.
Please give. My lord, I have analyzed the copy of the order. In this case, solicitor general earlier was appearing. Your lordship directed matter may be listed after the puja holiday. Your lordship, say any date, my lord, so that both the parties, the council, or appearing for the outside date to that. Any date. I have copied, analyzed the copy of the order.
May it be the lordship, my lord. Based on regarding land access.
Land action, rehabilitation matter is a final.
This matter, the vehicle has been, the prisoner has taken a loan and 70% of the amount he has paid and last EMI is to be paid in the year 2026. For they are threatening to sell the vehicle by after seizing it.
No,
It's a genuine matter, it may be taken up
I
tomorrow.
think that the matter is now assigned to other bench, not this bench. So DRT, surface line matter, no?
Surface.
That is assigned to Justice K.R. Mahapatra. Please see it.
May I please, Lordship? Let's see.
Please, Mera criminal option bench.
May I please, Lordship, this is the jail criminal appeal. The petitioner is in custody since 21/5/2022, Lordship. And their prima facie there is no.
What do you want? Bail?
Yes, Lordship.
Please give it. I don't know, Lordship. Prayer on the rehabilitation employment. Employment for rehabilitation. Please give it.
My lord, this is a regulation, WA matter, my lord. 2018 matter, please.
Weekly list item number 1.
Here, petitioner land had already acquired and possessed by the government for construction of the railway overbridge. And they have relinquished their share and construction has already been completed. But the dispute inter se lies with the determines the compensation under the new act. So the problem here, the annexure 1, my lord, page 1, page 24. No, you come to your repetition because I think this is your third repetition. Third. Come to paragraph 24. Right? Paragraph 24 of your repetition. 24. Page number 17. Yes. My lord, please read it. Please read that paragraph. Page number 17, paragraph number 24. My lord, that in your such order, Mr. Counsel, I am asking you to read paragraph number 24, page number 17. Petitioner said earlier filed a petition seeking appropriate direction to the opposite party for appointment for the land loser affected by the land acquisition terms of Railway Board instruction dated 16/7/10 or further instruction of the board dated 11/11/19 regarding payment of lump sum compensation to be provided to the affected family with leave of employment. After hearing the party, this Honorable Court disposed of the writ petition on 25/7/22 that the petition number 4 to 9 to approach the opposite party of 10 Secretary Department of Revenue Disaster Management by filing a representation reference to the prayer for availing the benefits under serial number 4, second schedule of RFCTA RF 2013, along with certified copy of order for registered post within a period of 2 weeks. Now you come to that copy of the order that is annexure 21. Yes, my lord.
This is the order passed in your last restriction, right?
My lord.
Page number 104.
Yes, my lord. My lord.
Come to paragraph number 2 onwards.
My lord. Whereas
No, not whereas. Paragraph number 2, page number 104 is the order dated 25/7/2020.
paragraph 2, my lord.
Yeah.
At the outset in oral prayer, Mr. Mahant is permitted to include the state of Orissa as opposite part number 10 to the read application in court today. He also makes it clear that he is confining this prayer to the petition number 4 to 9 and to prayer number 2. He also permitted he will be permitted to file a fresh application vis-a-vis the petition number 1, 2, 3, 10, 11, and 12 prayer is allowed. So accordingly, so petition number 4 to 9 are aggrieved by inaction of authorities, more particularly state of Odisha, in offering them employment, so their lands have been acquired long back for purpose of construction of approach road to the railway overbridge at Talche. In this context, it draws the attention to this court to the provisions made at serial number 4, second schedule of the right to fair compensation, transference, land acquisition, and rehabilitation resettlement Act 2013. Mr. So submit that for redressal of such of such type of grievance, the petitioner number 4 to 9 should have approached the state first instead of rushing to this court. In such background, so submits that liberty be granted to the said petitioner to approach the appeal part number 10 by filing a representation for redressal of the grievances and further praise that the said appeal party be directed to take a decision on such representation within stipulated period. Considering submissions made and without expressing an opinion on the merits of the case, this court grants liberty to the petition number 4 to 9 to approach the OP number 10 by filing a representation along with certified copy of this order to registered post within a period of 2 weeks. In the event such an application is filed before the OP number 10, he is directed to take a decision on the same in accordance with the law within a period of 3 months from the date of receiving such representation, after giving an opportunity of hearing to the petition number 4 on behalf of the petition number 4 to 9 and communicate the result of such exercise to the petition number 4, who in turn is directed to share such information with other petitioners.
All right. So when you earlier last time approved this court, in the operative part of the order, two things were told to you, that you are to file a representation with the certified copy of this order. Number 2, that representation has to be considered by the opposite party, number 10, and opportunity of hearing is to be provided to petitioner number 4. Did you file the representation? Where is that representation?
Right after his representation has been rejected, his file his representation was rejected.
No. In terms of this order, there was a direction to file a representation. Where is that representation? Where is your averment that in pursuance to this order, you filed a representation? On what grounds you have taken in that representation? And so that the impugned order was passed, not taking into account the points raised by you. Unless that representation is filed, how can we know what grounds you have taken to substantiate your claim for compensation?
Well, in fact, this representation is not in order. And the representation is filed and
No, I have verified at least that it should be serially, na? Once this order is passed, thereafter what you have done, it should be serially annexed that this representation has been filed. Averment should also be taken that I filed the representation in portions of the order and I raised this point, and no opportunity was also, personal hearing was given to opposite party. No such averment at all been made in the writ petition. It's this writ petition lacks a pleading, the substantial part which you are required to do, that is missing in this.
That is
Because the impugned order also does not indicate that you file any representation. The impugned order simply indicate that you produce the one order was produced, that is in the second paragraph, that WPC numbers 1. And basing on that order, the authority has passed the order. Neither it is mentioned any representation was filed, nor it is mentioned about the personal hearing afforded, and what are your grounds you have taken in your representation, how the authority dealt with it. Those things should have been reflected in the pleadings of your writ petition. That is not there. So how can we challenge such an order without those pleadings?
and filing applicable because when the government sent a letter to us
Mr. Counsel, you see, you are to amend your writ petition. Amend in the sense that not only you are to file that representation, but you are also to take the grounds that in the representation I have taken, these are the grounds, because you have already received compensation, but the compensation,
sorry, file.
whatever you want, that you have not got.
No, আমার সেই problems last year.
That, you see, once you take that representation and mention that these are the grounds on the basis of which I claim representation, I have filed representation, and the authority has not considered at all. And it also appears that personal hearing has also not been afforded.
Yes, my lord.
আরে সেগুড়াক ground ନବା କଥା ନା ନାଇଁ?
Sorry, my lord. ମାନେ ଆମେ
ଆପଣ ସବୁବେଳେ copy paste ରେ ଚାଲିଲେ ହବ।
ନାଇଁ my lord, ଟିକେ ସେଠି problem ଟା law ଆମେ chief secretary was holding just ଖାଲି 5 minutes ର ସେ କହିଲେ ମୋର I have no time, ସେ delegate power କରିଦେଲେ joint secretary। ସେଠି problem ଉଠିଲା my lord, ଏଇ ଯୋଉ notification ଟା
Once this is disposed of in this manner,
yes,
it amounts to flouting the orders of this court. He cannot do it.
yes, my lord.
There is a specific direction that you are to give opportunity of hearing to petitioner number 4. If that has not been given, if you take such ground and they will say, then that is itself a ground to set aside the order and remand the matter to the authority to give an opportunity of hearing. But you have not taken any ground.
My lord, I'll take a lost little the notification my lord ହେଲା,
You are again going to that.
ନାଇଁ
This is your, you don't forget that this is your third writ petition. And whatever has happened after the passing of the order of this court in that writ petition, that you are to highlight vis-a-vis this illegality in passing the order under Annexure 23. That you have not done. Those pleadings are missing. To amend the writ petition, all right, after hearing for some time and going through the order passed by this court in the last writ petition filed by the petitioner in WPC number 14663 of 2022, which was disposed of on 25/7/2022, we find that the petitioner has neither annexed the representation stated to have been filed in portions of such order, nor he has taken any averment in that respect in the writ petition. In this court, in the aforesaid order, also directed the authority to afford opportunity of hearing to petitioner number 4. Though the learned counsel for the petitioner urged that no such opportunity has been provided to petitioner number 4, but the in the writ petition, no such grounds are being taken. The learned counsel for the petitioner seeks some time to amend the writ petition by filing an interim application. Put up this matter in the week commencing from 10th of February 2025. Interim application for amendment be filed in the meantime, giving copy to the land council for the state and other opposite parties. Yes.
We are for the opinion number 1, 2, and 3,
Yes. Number 1. Mr. You are also to directed Mr. Padhi,
My lord.
you are to take instruction on that notification issued by the Government of Orissa in Revenue and Disaster Management dated 7/2/2024. And
Yes, my lord. We'll obtain. Next date will
we handed over to the state.
I amended it.
I have received my notes, I have gone through.
Okay, let him amend the prayer and then we'll see. Yes.
mobilize, my lord. Yes.
Item 2,
I want to take on attention to the last order sheet. Not directed the state government.
Please read that order.
May I please? Order dated
13/1/25.
31/25.
Please place that order.
Yes. The matter is taken up for hybrid arrangement as per order dated 17/12/2024, which is a pertaining question referring to the section 2C of the Odisha Communal Forest and Private Land Provision of Alienation Act. To whether the land pertaining to certificate from the company also shall be declared to be a forest land by notification of the federal.
Your voice is so slow, it is not audible, Mr. Council.
Sorry. The forest land by notification of the state government. The land and council for the state took some time to obtain detailed instruction in that respect. Today, the land and council for the state submitted that we have obtained instruction that there is no such notification issued by the state government declaring Khata number so and so as forest land. Clear to matter, and council for the state file an affidavit to that effect by the competent officer of the government. If the matter so and so copy of the affidavit.
And that's copy of affidavit. That's I'm placing.
What you have stated in the affidavit.
Well, there is no such note. There is no such note.
You take instruction on this affidavit.
The government was.
He has stated that he has already handed over you the affidavit. So take instruction.
One point I have raised that TV was a Godawan case.
No, I am not raising that in that.
Please go through the affidavit. Don't be in a hurry. In pursuance of the order dated 13/1/2025, the Land Council for the state has filed an affidavit on behalf of opposite party number 3. Order dated 13/1/25. The affidavit is taken on record. A copy of the affidavit has already been served on the Land Council for the petitioner. You seek some time to obtain instruction on the affidavit. This matter will be commencing from 10th February 2025.
item 3,
Changing the order of the tribunal at Annex 21, days 1 to 120. Operative personnel. I think that is 122. Paragraph number 14.
Yes.
That the present issue was considered by the Central Action Tribunal Principal Bench, New Delhi, in way number 896 of 2007, judgment dated 21/28/2014, as observed by the Central Action Tribunal Principal Bench, New Delhi, in way number 7 of judgment dated so and so, at paragraph number 28 at page 17, in view of the same railway authority. Initiation of disciplinary proceedings prior to without establishing subletting of water without giving opportunity to review the allegations against him as required under the principle of natural justice and arriving at the conclusion on the basis of inquiry conducted by the committee of officials behind the back of all others, that the accommodation has been subletted, etc., which are contrary to the rules and their own circular referred above, and the judgment of the Honorable Chair Intelligence News General, the condition of the liability person will to be allowed extending all the benefits in the facts and circumstances to allow the way and was and set aside the proceeding by charge memorandum dated 21/8/2015. He also was and set aside punishment order dated 28/1/2006 and subsequent orders of appellate and regional authority and accept
So the allegation against the applicant
that he has subletted
that she has sublet the house
No.
or the furniture to somebody else.
No.
So you have found her guilty or the held that charges have been proved, but all these basic things regarding opportunity of hearing, initiation of the disciplinary proceeding, and that was not been provided to her.
Now, this is here what happened. A joint verification committee, joint verification committee has conducted an inquiry on 3 dates. 14 employees have found that they subletted the waters to some other persons. Accordingly, on the basis of that joint verification committee, we asked for show cause and on the thereafter asked for rule 9 of the rule 9
So,
of
so was the rules.
this is
Whether the inquiry has been conducted
Yes,
or
yes,
not,
yes,
she has been
this is-
afforded opportunity.
Here what happened, disciplinary proceeding has been initiated, inquiry has been conducted, inquiry officer was appointed, sufficient opportunity has been provided, and thereafter penalty punishment has been.
What was your stand? Let us see. If you have submitted or
Uh,
served a copy of the charges on her,
Here-
she must have filed the written statement, the show cause. ଆପଣ ତାଙ୍କୁ charges serve କରିଥିଲେ ନା ନାହିଁ?
Yes, yes.
So what is those charges?
That's my-
Let us see that. And she must have also filed the statement
Page
Defense-
24, man.
24. Let us see.
Page 22 and 23 is the joint verification report, and page 24 is the memorandum of charges.
20.
24 annexure 3, man.
कौन लेक्चर में अपन बदले
The president railway board undersigned Hindi and
ଏଇଟା
English.
ଏଇଟା କଣ ଏଇଟା ମାନେ ଏଟା ସାଇକ୍ଲୋଷ୍ଟାଇଲ ଫର୍ମାଟ ଅଛି ତା ନାଁରେ ଅଭିଯୋଗ କଣ ଆପଣ କଣ ଦେଇଛନ୍ତି
ଅଭିଯୋଗ ଅଛି ଲାଷ୍ଟ ଅଛି ଆଜ୍ଞା
କଣ ଟା ଦେଇଛନ୍ତି
next page 26 ରେ detailed charges ଅଛି annexure to for number 5 ରେ statement of article of charges from S money page 26
Yeah.
that the said Srimati N money while functioning as such failed to maintain deviation of duty in as much as they subletted the railway quarter number 20 at jail area. She has thus failed to maintain devotion to duty and thereby committed an act of serious misconduct in violation of Rule 15A and 313 of RS Railway Service Conduct Rule 1966, which lays down that every railway servant shall at all times maintain devotion to duty and do nothing which is unbecoming of railway servant and therefore rendered herself liable for disciplinary action being taken against him under RCDN Rules 1968 as amended from time to time. Subsequently, Article 1 that Srimati N money has been employed as OS control of the such and such subletted railway quarter such and such during the surprise joint verification by the nominated committee while conducting door-to-door survey at jail area at Visakhapatnam on 27/6/2015, 29/6/2015, and 3/7/2015. It has been found that the railway quarter number 7 is under unauthorized occupation. The said accommodation likely to Srimati N money under so and it is under her occupation since 23/12/2005. On verification, it has been found that his said quarters sublet to outsider. He has failed to maintain devotion to duty and thereby committed an act of serious misconduct in contravening the provision of Rule 15A, G1 of RCS, under which 1960, which lays down that every railway servant shall do nothing which is unbecoming of railway servant and therefore rendered himself liable for disciplinary action being taken against him under RSDN Rule 1960 amended from time to time. Thereafter, he has submitted the reply at Annexure 4, your office memorandum such and such, the charges framed against me are concocted, fabricated from the material facts, and as I categorically deny them. And the inquiry officer was appointed under 9 such and such, and where the undersigned procedure and inquiry officer should be appointed to inquire into the charges framed against him, page 29. You understand? DPJMX, inquiry officer. Inquiry officer also conducted inquiry, provided all the documents, and she has been given opportunity. She has questionnaire, question answer. She has been examined. Witness has been also examined. All the document has been.
Yeah, just a minute. So, as it seems, uh, this joint verification which was made by the nominated committee, they visited the house in question, the quarter in question on 3 dates. So if you visited that quarter on 3 dates and found that the outsiders are there, then who are those outsiders who are staying there?
Those outsiders might have some of they are
You have not examined them. You have not examined them. You have not given the identity of those outsiders.
So far present case is concerned, she has stated that she is my aunt and she is doing business in front of the house.
No,
So
no,
40
no.
numbers of tires are there.
What she has done, that's a different matter. what you have done, that is most important. You are uh, uh, accusing against that lady or the applicant in the original application that she has sublet the house to XYZ. Let us say XYZ. Who are those XYZ? You have not stated. Simply stated that you have subletted. And your basis is that on 3 dates you visited the house. Now, those persons who are staying there, as you say, they are not coming to the picture. The neighbors who could have been examined, they have not been examined. So, on what basis you say that some persons were staying? Who are those persons? How they are staying? All these things are required to be
Page
at least brought on record.
page 30,
Page
37.
yeah.
During the inquiry, all the witnesses stated that when the committee
You are reading who page
page
30,
37.
37.
During the inquiry, it starts from during the inquiry.
Have you given the opportunity of cross-examining this?
Yes, cross-examination.
Let us see that what have you stated.
During the inquiry, all the witnesses stated that
37 though?
my
37 hour. Yeah, yes.
during the inquiry, all the witnesses stated that when the committee members inspected the quarter, they found some outsiders, non-railway employees staying in the quarter, and they asked to show the ID proof like voter ID card, medical card, Aadhaar card, gas card, or any other ID proof. But they could not produce any proof. When they asked to one of the lady members inside the quarter about the original allotee of the quarter, she replied that she is residing somewhere in Allipura. When asked how she is staying, the lady replied that they are known persons. When asked whether she is paying any rent or not, she did not reply anything. The neighbors verbally stated that quarter is under subletting, but refused to give written statement to avoid any litigation. The original allotee was given time up to 3/7/2015 to produce ID proof, but she failed to produce the same before the committee. Finally, the committee come to a conclusion the quarter was subletted.
So suppose let us say one day your committee members visited that house. They found one lady is there and inside that quarter, and they asked that how she is staying there in that quarter. The lady replied that they are known persons. This is the reply given.
Right.
So suppose a known person stays of an employee, railway employee, stays for a temporary period in the house of that employee. Can it be presumed that this how quarter has been sublet to that lady?
But during the cross-examination, everything was found that has been subletted.
Then let
And
us see that.
he has not raised that point also.
No, let us see that very
Plus, next,
what you have brought on record.
for my lord. Next page 38. Question number 4. What you have noticed?
Mhm.
Next page 38. Last towards last. Question number 4. We asked joint verification members, the resident of the said quarter, to show the ID card, the ration card, Aadhaar card, gas card, etc. of the allotee of the quarter, but nothing has been shown to us. How will you prove that the quarter is subletted since ID proof of the allotee of the quarter has been shown and we are inquired the surrounding people of the quarter? They also disclose that some outsiders are residing in the quarter. Then my page 40.
Yes.
In your answer to question number 4, you have stated that you have subletted the you have asked the residents of the said quarter other than the substances to show the ID card substances of the allotee of the quarter. Since they failed to produce, you have arrived at a conclusion that the CO has subletted the house. Kindly clarify the ID proof of the not any basing upon the failure of producing ID cards, but also the surrounding resident relevant That's some of the
तो आपनकर एंटायर केस होची जो दिन आपण गले गोटे लेडी मेंबर सेठी थिला एवं सी कहला हमर ये जनाशुना ये जो एम्प्लॉई जनाशुना एवं आपण तम कहले जे आपनकर आईडी कार्ड दियंतु रेशन कार्ड दियंतु आधार कार्ड दियंतु गैस कार्ड दियंतु सी आपण पाखे प्रोड्यूस करि पाइले बाकी नेबर टू बुझिले नेबर्स कहले जे से एटा सबलेट हेछि तो नेबर्स जेतु एग्जामिन हेइ नांती वो जो लोक ये हेछि से भी एग्जामिन हेइ
examined or not, let me go through these questions once again.
हां
Neighbors has been examined or not, let me go
see
through.
you are
But here the question is,
yes
here the question, he has not read the disciplinary proceedings. He has stated that prior to initiation of disciplinary proceeding, he should have asked for show cause.
no please show the original application
Original application, my lordship.
what are the grounds
Page 72. 72, the grounds, my lord, page 82.
page
Page 82, my lord, the grounds of original application.
yes
For that, the assistant operational manager, B.B. Jena, who was appointed as inquiry officer by the disciplinary authority, is the person who has instructed the West D&A to issue major penalty charge memo in form SF5 against the applicant, as is evident from Annex 1, and also issued instruction to the divisional personnel officer, USCO as advised by the ADRM such and such, to the appellate authority to cancel the allotment of the quarter, initiate eviction proceeding, and to recover penal grant from the applicant as chairman of the such and such, which shows that the prosecution acted as judges of their own case vindictively with government mind and punished such and such. Further, the order of punishment awarded by the different authority shows did not apply his mind to sub-rule 5 of Rule 10 of DA rules, where he has not considered at all the evidence adduced during inquiry, and also the punishment awarded by the different authority is stated and took the report of inquiry officer granted and acted on it mechanically without application of mind. Further, the appellate authority also passed an non-speaking order in general manner contrary to sub-rule such and such. Hence, both the punishment orders and the appellate orders are liable to be passed. For that, initiation of the disciplinary proceedings against applicant prior to and without establishing subletting quarter is itself is bad, and order of punishment and confirm action by the appellate authority and regional authority of similar liability.
so this is the main thing you see you are removing an employee on the ground that the room he has been allotted with a room railway quarter which she has sublet to X sublet खाली कहउछन आपण किंतु से जो सबलेटिंग एस्पेक्ट ता जदि आपण प्रूफ न करि पारले in the so how do you say that
Even if your office kindly see joint on 3 that joint verification committee has conducted.
yeah
It is a committee which is duly constituted by the railway department.
no
And
what
14 numbers of employees.
what you no see अन्य कथा छाड़ दे आपण प्रत्येक दिन जो गले what you saw तीनटा डेट रे आपण जाइछन से तीनटा डेट रे प्रत्येक दिन आपण कोन देखिछन काहा को देखिछन काहा संगे आपण इंटरेक्शन है ए जो आर क्वार्टर रे
A lady, my
नहीं काई आपण करो ये
yes,
काई
yes,
वेर इज योर दैट ए दिन हमें या देखिलु
yes, सेटा लिखा है कि वो जगह में लिखा है.
some known person suppose comes to the quarter of an employee and stays there for some days that does not mean that it was sublet to those
But here, my lord, business purpose it has been subletted.
huh?
Because business materials are there.
No there is nothing
Yes, yes.
where is your charge
Put there देखी चले. The market.
आपनकर रिपोर्ट टा होची तीनटा डेट रे आपण गले एवं तीनटा डेट रे देखिले लेडी टी अछि लेडी को आपण मागिले ई कार्ड दियो
Again.
से पहुंच प्रोड्यूस करि पाला नाही किंतु से कहला जे हमें होची तांकर जणासुना लोक ए जो एति होची आपनकर एविडेंस तापर कोन पड़ोसी को पचारले पड़ोशी कौन कहला से पड़ोशी तो ना एग्जाम नहीं ना किसी नहीं हाँ तेबे आपण जो जो तीन टा डेट रे जाइछंती पहुंची छंती ते तीन टा डेट रे कौन हला किए थिला ए सब काई एविडेंस काई किए जाई थिला तीन टा डेट हम्म हम्म से लेडी को जे पचारले ये तो किसी तार भी सिग्नेचर की भी ऑब्टेन करना थी से थिला बोली आपण को बेसिस रे आनले तो ये जिंस तो घरे बसी कर ही जीवो ना काकू विंडिक्टिव हे कि नहीं गोटा रेलवे एम्प्लॉय को आपण कर देबे आपण तीनटा डेट रे आपण गले जरी केही देखिलेनी तेणु एटा सबलेट ହେଇଛି तेणु किए से काहाकू दिया गला कौन दिया गला हाँ तीनटा डेट रे आपण जो स्पेसिफिक आसीबा दरकार
good ଜାଗାରେ ଅଛି ଯେ 40 numbers of tires has been ଗୋଟେ business establishment ତ ସେଟା because it has been drafted by one another accountant ମୁଁ ଆଜି ପଢୁଥିଲି today I received the bill.
then you go through it there is no problem there is no have taken so many things. You see, somebody is staying there, at least recording of something, voice, photographs, anything could have been done. Neither signature, nothing. Who is that lady who was staying there? See, totally, appears to be a suspicious thing. आपण खाली କହିଦେଲେ ଗୋଟେ ଲେଡି ରହୁଥିଲା ଏ ଟାଇପ ର କଲେ କେମିତି ହବ ଆପଣ ତାକୁ ଚାକିରିରୁ ବାହାର କରି ଦଉଛନ୍ତି ସେ ରେଲୱେ
Reduction of
whatever
scale has been
ହଁ
taken up Friday night. This Friday. I prepared the question answer which has been written in handwritten also because that is not legible.
ଆପଣ ଯଦି ପ୍ରଥମ ଡେଟ୍ ରେ ଦେଖିଲେ ତାପରେ ତ ଆପଣ ଜଣେଇ ଦେବା କଥା ଯେ ରେଲୱେ ଏମ୍ପ୍ଲୟି କୁ ଯେ ଆମେ ଯାଇଥିଲୁ ଭେରିଫାଏ କଲୁ ତିନିଟା ଡେଟ୍ କାଇଁ ଆପଣ ରହିଲେ
ତିନିଟା ଡେଟ୍ ରେ ସମସ୍ତ 14 ନମ୍ବର ଚାଲିଛି
ନାଇଁ ନାଇଁ ୟା ଘରୁ କେବେ ଯାଇଥିଲେ ତିନିଟା ଡେଟ୍ ରେ ଆପଣଙ୍କର 40ଟା ଘର ଆପଣ ଭେରିଫାଏ କରିଛନ୍ତି ତ ଏଇ ଯୋଉ ପର୍ଟିକୁଲାର ଲେଡିର ଆପଣଙ୍କର ତା ଘର କେବେ ଭେରିଫାଏ କରିଥିଲେ ଗୋଟେ ଡେଟ୍ ରେ ନାଇଁ ତିନିଟା ଡେଟ୍ ରେ ଯାଇଥିଲେ
ତା ଘର ଯାଇଥିଲେ
ଆପଣ ତିନିଟା ଡେଟ୍ ଦଉଛନ୍ତି ଡୋର ଟୁ ଡୋର ସର୍ଭେ କଲେ 2700 2900 ଆଉ 37 ଏଇ ଯୋଉ ତିନିଟା ଡେଟ୍ ରୁ ଏଇ ଯୋଉ ଆପଣଙ୍କର ଲେଡି ଯିଏ ଅରିଜିନାଲ ଆପ୍ଲିକେସନ ର ଆପ୍ଲିକାଣ୍ଟ ତାର କ୍ୱାର୍ଟର କୁ କୋଉ ଦିନ ଯାଇଥିଲେ ଆପଣ ଏଗୁଡାକ ଆଣିବା କଥା ନୁହେଁ ଗୋଟେ ଜେନେରାଲ ମ୍ୟାନେଜ କହିଦେଲେ ଆମେ ଡୋର ଟୁ ଡୋର ସର୍ଭେ କଲୁ ଇଏରେ 40ଟା କ୍ୱାର୍ଟର
3 dates we have visited in order to substantiate their truthness.
Whether you visited on all this quarter
whether all dates or one day.
That is exactly it. So get yourself prepared. We are adjourning the matter. Mr. Gupta, Land Central Government Council, after arguing for some time, 6 for an adjournment till next week. One of this matter is commencing from 3rd February 2025. Yes.
Item 4.
And the cases of the petitioner is that the order passed on the annexer 1 passed by the appellate party number 3.
Please come to the last order.
My lord, I have submitted the documents what have been submitted to
Please
ASO.
come to the and place that order.
My lord.
15-125.
My lord. The matter is taken up for hybrid arrangement. And counsel for the petitioner submit that in pursuant to order dated 19/12/2024. He has got the relevant documents and which were filed before the ASO in the objection case number 83/4/2012 for recording the name of the petitioner in ROR. He has to file those documents with an affidavit during the course of this week, giving a copy of land council for the state. On receiving of the affected document, the land council for the state shall obtain instruction from the concerned authority as to whether those documents were produced for recording the name of petitioner or not.
So you handed over the document
My lord.
with an affidavit.
I have some.
What is your instruction?
22nd, my lord says.
The land council for the petitioner submitted that as per the order dated 15/1/2025, he handed over the relevant documents to the land council for the state with an affidavit. Stop. The land council for the state submitted that the documents with affidavit has been handed over to him on 22nd of January 2025, and he is yet to receive instruction on such documents, and the matter may be taken up a week after. Place this matter in the week commencing from 10th of February 2025.
Item 5.
Five, my lord, order dated 8/1/2025 is to be complied.
Yes. 8/1/25.
8/1. Second page of the order.
Yeah.
Third sub-paragraph. Let a report be called for from the collector Sambalpur as well as additional proceedings further Sambalpur as to why there is an inordinate delay in disposal of the vehicles case number 29 of 2003. The report will produced before this court by the learned public for the state. I have received instructions, but they do not comply with my lord's order. Ignore the first part, the second sub-paragraph, my lord. I have already discussed in the morning. Today, my lords, in a week's time, I will call for a detailed report.
So it is still pending.
He is disposed of, but he could not have.
Oh, he disposed of.
He could not have.
Then it should have been intimated
Exactly.
to
Which is why my lord says that my lord may ignore the first part. The delay part, 3 lines he has written, but that does not comply with my lord.
the computer. The case has been disposed of accordingly. Disposal order ta kahin?
He hasn't, which is why my lords, I am praying that my lords may ignore the first part. The second part is actually in compliance with my lord's order. He could not have disposed of without issuing notice to them, which is why I have told him that he could not have done this. And the second part does not comply with my lord's order. He has to give details of.
No. It's first of all, we just want to know that whether it has been disposed of or not. He has stated that disposed of. If you have disposed of, there must have been some order.
Exactly.
So where is that order?
Could not have, my lords. There is no notice to him.
That is exactly, he is raising that to.
This, my lords, I received only on Friday. So he could not have, which is why, my lords, I pray for some more time. Maybe he is not able to understand, although I have spoken to him.
Oh,
I will
I have
filed that certified copy of the total
Yes.
order sheet manner
Yes.
at March 10 manner. That does not show that they are disposed of. Man, it was pending.
Instruction that they did, he hasn't understood.
ଏମିତି ଯୋଉ 8/1 order ହେଲା ପରେ ଆଉ ତରତର ହେଇକି ଗୋଟେ କରିଦେଇକି
Which is why, my lord, I'll need to talk to him. I'll do it.
ପଚରା ପଚରି ହବ କାହିଁକି ଛାଡ଼ିଦେଲେ ଗଲା କାମ।
Okay. No, I'll speak to him.
ଦେଖନ୍ତୁ, the Learning Council for the state has produced the written instruction received from Tahsildar Sadar Sambal dated 24/1/2025, which indicates that OGLS miscase number 29 of 2003 has been disposed of. However, the order of disposal has not been sent along with the written instruction received. The land counsel for the petitioner, on the other hand, submits that he has not been noticed participate in the proceeding and to have his say. Land counsel for the state seeks some further time to obtain instruction in pursuance of the order dated 8/1/2025, and also to produce the result of the disposal of the OGLS, the entire the order passed while disposing of the OGLS miss case number 29 of 2000.
Yes. So ଏଇଟା ନଥାଉ, let me get detailed instruction from
Like କାରଣ ଏଇଟା ଯଦି disposal ଅଛି ଏଇ ground ରେ
ସେଇଟା
ସେ
ମୁଁ
ପୁଣି amendment କରିବେ
କରିବେ
ସେଇ ground ରେ ପୁଣି
dispose of ହେଇନି because it's told me now because I spoke to him
ଆଚ୍ଛା।
in the morning 24 ରେ ପଠେଇଲା ପରେ I wanted to find out
dispose of fact.
ସେଟା କାଟି ଦିଅନ୍ତୁ, ଏଇଟା ମୁଁ ଖାଲି ଆଣୁଛି, ସେଟା କଟ just to show my lords that
litigation ଯୋଉ ଆସୁଛି
ଆଜ୍ଞା।
ଏଇ type ର ସବୁ
my lords
ଦେଖନ୍ତୁ ଏତିକି ଲେଖିଦେଲା ପରେ କହିବେ କି however he wants to obtain further instruction in the matter for the ଛାଡି ଦିଅନ୍ତୁ ହେଲା। This matter will be commencing from 10th February 2025. Yes.
Item 6.
I will prefer with more time to obtain the certified copy of the and title of the
That is the order dated 2/12/2024.
Yes, I have not been able to get the certified copy. But can you allow me to
Just a minute, let us see. Who made a query to the land council for the petitioner as to whether the lands which were subject matter of the title suit, so also in the title appeal, and whether there is any link with this present proceeding is submitted. So the said title deed appeal is pending against the order passed in the title suit, and the petitioners are the appellants in the title of it. Let the land council for the petitioners file the copy of the grant and decree passed in the title suit numbers 1-2 in the Code of Civil Justice Senior Division Code. So also the copy of the appeal memos also. So you seek further time.
Yes.
All right. The land council for the petitioner seeks some further time to comply the order dated 2/12/2024. Is this matter 10 तारीख रे रखिला ना और दिया समय February date लिखिए। 10th of February 2025. Yes.
Item 7.
Last time you was directed for instruction in appearance of Have you given a copy to the learning council?
just now.
So what is your report, Mr. Please place the report. You are not having the copy. I would copy करता हूँ please. ଆପଣ ଜାଣିଛନ୍ତି ଡିଭିଜନ ବେଞ୍ଚରେ ଦିଟା କପି ପଡିବ ତାଙ୍କୁ ଗୋଟେ ଆଉ ତେଣୁ ଚାରିଟା କପି କମ ସେ କମ କରିବା କଥା ଆପଣ ଅଫିସ କପି କେମିତି ରଖିବେ ଏଇଟା କରିଦିଅ କରିଦେଇଛ please paste. ସେଟା ଅନ୍ ଅଛି ତ ସେ ମାଇକ୍ ସେଟା ଅନ୍ ଅଛି ସ୍ପିକର ପଢନ୍ତୁ।
On verification, it is found that plot number 32650 area 1320 under the Khata number 619 relating to Mauja Chandrasekhar is coming within the campus of the Watco subdivision 1, Chandrasekhar, Bhubaneswar. That land is under the khas possession of the government. The government office is functioning over the suit land. lease and alienation of government land is Bhubaneswar is governed under the provision of the Odisha Government Land Settlement, Second Amendment Rule 2020. There is no provision for settlement of the land in favor of the individual person. The entire premises are coming under the Watco premises. It is not a permissible under law of settle allowed the state within a permission of government office. The reply to the query is indicated below. The petitioner is retired employee of the Watco. As a ascertained during field inquiry, he is trying to grab the valuable government land situated in the public office. Watco has issued a notice on answer 4 to the petitioner for vacation of the government land, but the enclosure has not yet been vacated the land. There is no provision for settlement under the OGLS Second Amendment Rule 2020. G and PG Department is following this rule is allotted to land with BMC area for institutional purpose. There is no scope for the settlement of the individual person under this rule. The petitioner has not yet vacated the enclosed land despite a notice by Watco by the answer 4 of the petition. In this connection, it is important to say that the claim of the petitioner for the settlement of government land within a government premises is bad in law. Section 2 of the Odisha Government Land, the bar to application the right of the Occupants Act 1950, provided no right of occupants shall be created in respect of the land under the occupation of the central and state government.
Yeah, what do you say?
Your Lordship, our glance at Annex of P at page 19. There is a household list of from survey. Alternate arrangement for land. So we are not on that point. That I am not in that point. That the land in that place, intended was slum area, may be allowed. But
ତାଙ୍କ ପାଇଁ କିଛି ଅଲ୍ଟରନେଟ୍ ଆରେଞ୍ଜମେଣ୍ଟ କରିଛନ୍ତି ଆପଣ ଲେଖିଥିଲେ ଯୋଉ ଗୋଟା ସର୍ଭେ କଣ ହେଇଥିଲା 2012-13
more than 100 families are now there. Really, notice has been issued to petitioner.
So 2 series that is the that the साधारण प्रशासन विभाग.
ନାଇଁ ନାଇଁ ଏଇ ଯୋଉଟା ଆନେକ୍ସର 3 ଉପରେ ସିଏ ବ୍ୟାଙ୍କ କରୁଛନ୍ତି ଆପଣ ଗୋଟେ ସର୍ଭେ କରିଥିଲେ ଏବଂ ସେଗୁଡାକ ଦେଖିଲେ ଯେ ଏଇ ଲୋକ ଗୁଡାକ ସବୁ ସେଠି ରହୁଛନ୍ତି ସେ ଯୋଉ ସ୍ଲମ୍ ସର୍ଭେ କଲେ 2011-12 ହେଲା ତାଙ୍କୁ କିଛି ଆସ୍ୟୁରାନ୍ସ ଭଳିଆ ଦିଆ ହେଇଥିଲା ଯେ ତାଙ୍କୁ କୋଉଠି ଗୋଟେ ଅଲ୍ଟରନେଟ୍ ଆରେଞ୍ଜମେଣ୍ଟ କରାହେଇଥିବ ଆଉ ଆପଣ ଯଦି ପୁରା ଏଣ୍ଟାୟାର ବସ୍ତି କୁ ଶିଫ୍ଟ କରିବେ matter is different, then why are you picking and choosing this person? ସେ କହୁଛି ଯେ ବସ୍ତିରେ 100 ଲୋକ ରହିଛନ୍ତି ଖାଲି ମତେ ହିଁ ନୋଟିସ ଆସୁଛି ଏଇଟା ୟା ଉପରେ କଣ କହୁଛନ୍ତି ଆପଣ?
On that part, we will take the instruction whether they are
file an affidavit or counter whatever you want to file. ତ ଯଦି ଉଠେଇବେ ପୁରା ବସ୍ତି ଇଏ କରନ୍ତୁ ଆପଣ ଯଦି ଅଛି ତାଙ୍କୁ ଆଉ କୋଉଠି ସେଟଲ କରେଇବେ ତାଙ୍କୁ ଜାଗା ଦିଅନ୍ତୁ କି ସେଟଲ କରାନ୍ତୁ ଯଦି ନାହିଁ ତ 100ଟା ଲୋକ ଭିତରୁ ଗୋଟେ ଲୋକଙ୍କୁ କଣ ପାଇଁ ଆପଣ ନୋଟିସ ଦଉଛନ୍ତି ଯେ ଆପଣ ଘର ଛାଡି ପଳାନ୍ତୁ ଏଇ ଯୋଉ ଫାଇନାଲ ଭ୍ୟାକେସନ ନୋଟିସ ଯୋଉଟା ଦେଇଛନ୍ତି ଦେଖନ୍ତୁ as per the order, previous orders to go. The Land Council for the state has produced a report from the Joint Director of State cum Additional Secretary to Government dated 27/1/2025. Wherein it is stated as follows, quote for them on verification route up to state government portion, bracket portion. The Land Council for the petitioner referring to Annexure 3 series submitted that it is the household list of 415 slums surveyed in the year 2011-12 and 2012-13. And hundreds of persons are staying in that basti, but only the petitioner has been issued with notice under Annexure 4 for vacating the house. The Land Council for the state seeks some time to file the response to this his counter to the writ petition. So we are putting it on 10th of February. All right. And specifically in that counter affidavit, you take into think that whether this so-called survey, which has been stated to have been held under Annexure 3, whether it is a genuine document or not, number one. Number two, whether the government is proposing to provide alternate arrangement to those slum dwellers, if they have got any plan to know. And if they have planned to evict those persons in providing so and so, then notices has to be issued to all the persons. They are occupying that land. So then why it has been issued only to petitioner, not to the others? The land and only one him, but not the other persons who are residing in the slum. Put up this matter on 10th February 2020. Yes.
Item 8.
Yes. Yes. What do you want? Don't tell like that. You tell us he has got some personal income. The mention is made on behalf of Mr. Kaur that he has some personal difficulty and the matter may be taken up in some other time. There's this matter we commencing from 10th February 2024. Yes.
Item 9.
Order of transfer has been intercepted with the central administrative tribunal is assumed before your lordship. Now,
Just a minute. There was an order passed on 21/1/2025. Submit that inadvertently so and so as a caveat has been attached to this. Those matters are not connected of them. Let the copy of the writ petition be served on the Land Council appearing for Union of India. It has been served.
yes. It has been
Mr. Pari.
We have received the advance copy.
Yes.
Only
Now,
we
what is
extra
the-
one extra copy is required to tell.
just a minute. What is the prayer here?
We have no grievance against the central government.
But it is single member actually.
The judgment of the honorable tribunal, wherein it has interfered with an
But
order.
this matter related to the single bench, not the division bench.
Order impugned is Central Administrative Tribunal's order.
Mr. Pari, the order is dated 23/8/2024, passed by the London Central Administrative Tribunal, Cuttack Bench, Cuttack. So, what is the question of it is going to a single bench?
It is item 9.
Of course, 9.
Then I am sorry, sir.
9, the order under challenge is the annexure 1, which is
Yes,
the,
yes, Navodaya Commission of Navodaya Vidyalaya. Yes, yes. It is,
Yeah.
yes, yes. Sorry, sir.
yes,
They
on
have
ground
filed.
you are
Yes.
challenging.
Transfer is effected in the administrative ground. They directly take your lordship to the transfer order that your lordship find out in page 92. Transfer order dated 5th of April 2024.
92.
Yes, madam.
Yes.
जवाहर नवोदय विद्यालय में
Yes.
in Hindi. जवाहर नवोदय विद्यालय खुर्दा उड़ीसा में पदस्थित सुश्री कविता कर को का स्थानांतरण प्रशासनिक आधार पर जवाहर नवोदय विद्यालय छत्रपुर मध्य प्रदेश को में किया जाता है. So this transfer is for an administrative exigence.
So what happened? This is May 2024.
Yes, madam.
We are now in January 2025.
Madam, this order has been challenged and this has been set aside, interfered with.
So
And the ground of interference is not quite peculiar. May I just take it?
no, interfere with means original application was allowed.
Yes, madam.
So who are you?
I am Navodaya Vidyalaya,
Acha.
the authority who transport.
So you don't want that employee in your.
Well, there is an administrative inquiry going on against her, and her continuation at that place will definitely affect the ongoing. We have placed on record the inquiry grievance applications being made to the Honorable Minister of HRD Minister, and that was forwarded to the Committee for the inquiry. We are in the midst of inquiry. Strangely, the tribunal has give a finding that as if there is nothing in the allegations, even prior to conclusion of an initial inquiry. May I just place my paragraph 4 of the impugned order?
Yes.
25. Paragraph 3, we have gone through, given our thoughtful consideration to the entire matter and have gone through the pleading. So far as the allegations of the respondent regarding the complaint made by the parents and students, parents of the students at JNT had annexed R 2, we notice that this is a common grievance of the parents to uplift the basic facility of the school, such as providing healthy environment for study, safety, and security to the residential facility in the school, management, foods, sports, and improvement in teaching. The allegation is not pointed towards the principal, that is the applicant only. It is also mentioned in the complaint that when principal...
He was the principal.
Yes, ma'am. The tribunal has almost given that there is nothing.
Just continue.
When the principal is willing to take some corrective attempt, then she was suppressed by the old staff to do so by threat of the student strike, worker strike. Hence, it should be the duty and responsibility of the authority concerned to look into the allegations and act as per the rule. But on such complaint, transferring a government employee principal in this case without going into the root of the allegations through inquiry, etc., is not appreciable at all. Case is that transfer policy I'm showing my lord on transfer our total case before the as per our written statement filed before the tribunal is that we are transferring her within the stipulated time because of the administrative expense.
Where is your that particular ground taken?
My lord, the lordship may kindly present case 100 100 and the
100.
yes. Paragraph 2.
Paragraph 2. Yeah.
That during tenure of the applicant while working as principal JNB Koda, complaints were received against the applicant regarding her conduct and lack of cordial relation among the school staffs and lack of smooth functioning of JNB Koda. Copy of the complaint received from the parents JNB Koda is annexed as R2. Now, my lord, at page 101, paragraph 4, the transfer policy 2021 under clause 4.1c envisages administrative transfer which is effected by the Samiti so moto in the exigency of service and administration ethics. Transfer policy of an employee whose continuation, well, we have quoted that. Continuation at a particular station is not conducive for administrative point of view. Such transfer may be executed based on certain inquiry, preliminary or detail, as considered deemed fit in the case and after recording the reason.
So here you have conducted that inquiry.
That is exactly what I have to. Subsequently, we have the internal inquiry is going on.
No. This, if
No,
you are
the
relying on
inquiry is
that,
not completed. Inquiry is going on. That stage we have transferred her. Initiation of inquiry is sufficient, madam.
no, this particular clause which you are relying upon,
Yes.
it indicates that if on administrative point of view, you want to transfer an employee, then it has to be some kind of preliminary or oblique detailed inquiry has to be conducted. And then reasons has to be recorded that this is on the administrative ground you are transferring it.
Yes, madam. I have
So what is the inquiry you have conducted prior to issuing this transfer order, and what you have found
inquiry
against?
is at page 29.
Yeah. When the transfer order was
On
issued,
5th April, we have passed the reason that it is required administrative and it was communicated on 13th April 2024.
where is that transfer order?
Transfer order as it's shown at page 92.
92
Yes, madam. Prasasanik Aadhaar पर
on a date tag is
date is 5th of April 2020.
5th of April. अच्छा 5/4/2024. ओके आपनकर प्रिलिमिनरी इंक्वायरी कौन हला देखिए
On a decision 2nd of April 2024.
हाँ कौन देखिए
With reference to the subject area, I am submitting here with the following facts of Srimati Kavita Kaur JNB. It is submitted that many complaints were received against Srimati Kaur, principal of JNB Khurda, in this office regarding her conduct and functioning in the Behera, due to which the understanding proposed to transfer her on administrative ground to or the other JNB University with personal relationship and other. Further, it is also the last part. Further, it is also mentioned that during her previous tenure at in charge principal at JNB Konjam, similar complaints were received against her regarding the engagement of teacher on contract basis at her own level and poor mess management, and it is also stated that she engaged in the mess employees for her personal one. The same was informed to JNBA NBS headquarters, while later so and so, along with a fact-finding report. Recently, we have received a complaint from the parents and students of Khurda, which were forwarded to JNB which is forwarded to NBC headquarters and later dated so and so regarding the various issues pertaining to the safety, security of the student, mismanagement of the Vedala.
This writ petition has been filed by the petitioners, Commissioner Navodaya Vidyalaya Samiti and Deputy Commissioner Navodaya Vidyalaya Samiti, challenging the order dated 23/8/2024 passed by the London Central Administrative Tribunal Cuttack Bench in way number 260 of the 00228 of 2024 by Director 1. Mr. Roth Land Counsel for the petitioner, to the attention of this court to the transfer order, which is कितना number page they पूछ रहे हैं?
92
92
communicated in 92.
Which is dated
5th of April.
5th of April 2024, which has been passed on the ground of administrative ground. Petitioner has been transferred to Jawahar Navodaya Vidyalaya Chhatrapur bracket Legnatu, Madhya Pradesh. He submitted that the rules টা could provide করছিল the proof
Page 89.
18.
Now, your lordship, the transport policies are
Policy টা,
at page 26,
20?
59. Page 59.
Page 59, just a minute.
Page 59.
ନା ଏବେ ଯୋଉଟା ଦେଖୁଥିଲେ ଯୋଉ inquiry
এটা ଦେଖିଥିଲି ମୁଁ କାଉଣ୍ଟରରେ ଲେଖିଛି କାଉଣ୍ଟରରେ ଲେଖିଛି page 101 ସେମ୍ ଜିନିଷଟା ଏଠି ପଡିଛି।
101, all right. He has referred to the transfer policy 2021 under clause 4.1 bracket C, that is in page number 101, which advises administrative transfer can be effected by the Samiti so moto in the exigencies of service and administration as well as in public interest. Subclause 3 thereof stipulates as on the subclause 2. The Mr. Roth Land Counsel for the petitioner referred to the annexure 2, which is the proposal for administrative dated 2/4/2024, which is the proposal for administrative transfer of the opposite party number 1, which indicates that after receiving complaints against the opposite party number 1 regarding her conduct and functioning in the Vidyalaya, and taking into account her interpersonal relationship, lack of interpersonal relationship between the staff, student, and associated stakeholder, lack of administrative skill, lack of mess management skill, and weak financial management. And her arrogant behavior, a fact-finding inquiry was conducted, and thereafter the transfer order was issued. The London Counsel for the petitioner submitted that the observation made by the London Central Administrative Tribunal that gross injustice has been caused to the opposite party number 1 in the decision-making process is not justified, and therefore the consequential quashing of the order of transfer dated 4/5/2024 is also not sustainable in the eye of law. We should notice on the question of admission indicating therein that the matter shall be disposed of at the stage of admission. Requisites for issuance of notice on opposite party number 1 and opposite party number shall be filed within a week with proof of delivery. Mr. Pari and the London Central Government Council na dedi chandi aguru.
Durga, Durga Pratap. Ita deinu dedi.
behalf of opposite party number 2. Extra copy of the writ petition be served on the Land Council. So far as opposite party number 3 is concerned, no notice is required to be issued to him, put up this matter 4 weeks after uh, counter affidavit, if any, be filed in the meantime. Yes,
और आइए notice है इसको.
I hear notice issue for them. This is an application for stay of operation of the order dated one. So issue notice, accept one set of process B. Yes, next.
Item 10.
Please, your lordship.
Yeah.
On the notice regarding acquisition of lands issued in favor of the co-sharers of the petitioner's mother. Thereafter, the petitioner's mother filed one
Madam,
document.
please come to the last order dated
Madam.
8/1/25.
Madam.
We asked you that about the status of
Madam.
CMA number 79 of 2024,
This is
and you said that there is no such progress, and you will produce the entire order
Madam.
sheet.
See. Okay. Before time of
CMA टा आपण फाइल करछंती.
expertise ହେଇଯାଇଥିଲା
ନାଇଁ ବୁଝିଲି.
ତାଙ୍କ ମଦର ମରିଯାଇଛନ୍ତି 3 ମାସ ତଳେ ଏକ୍ସପର୍ଟ ହେଇଛି ଆମେ ସେଟା ଫାଇଲ କରିଛୁ.
Just a minute. We have mentioned that in that order that Annapurna Dhol filed a civil suit
Madam.
before the Civil Judge Senior Division Jajpur for partition, and it was dismissed for default on 24/6/2024. And to set aside that dismissal order, the legal heirs of Annapurna Dhol, who died during the pendency of the so and so, filed the CMA for restoration of the suit, and the CMA is pending. So now they are taking time to file objection.
Madam.
All the opposite parties have entered appearance.
Yes, madam.
ଆଉ ଗୋଟେ କଣ SR ରହୁଛି ମାନେ ଆଉ ରହିଛି. So what is your prayer in this writ petition?
Under this, madam, kindly see, my lord, this honorable court's order, my lord, that is annexure 5.
No, you want to quash the order passed by the land acquisition
My
officer.
lord, my lord, because my lord, some of the parties, my lord, one of the party, my lord, one of the co-sharers filed one petition before the LA, before the land acquisition officer, my lord, which is marked as annexure 7, my lord, page 39. ନିବେଦନର କାରଣ ଏହିକି ଯେ ମୁଁ ଶ୍ରୀ ଧର୍ମେନ୍ଦ୍ର ରାଉତରାୟ ପିତା ଜୟନ୍ତ ରାଉତରାୟ LAK 4/13 ମୁତାବକ ରାୟ ଓ ଭଗବାନ ଜେନା ଅନନ୍ତ ଚରଣ ଜେନା ଏବଂ ଅଭୟ ଜେନାଙ୍କ ଜଏଣ୍ଟ ଆକାଉଣ୍ଟକୁ ଜମି ଅଧିଗ୍ରହଣ ବାବଦ ସମ୍ପୂର୍ଣ୍ଣ କ୍ଷତିପୂରଣ ରାଶି ପ୍ରଦାନ କରାଗଲେ ଆମର କୌଣସି ଆପତ୍ତି ଅଭିଯୋଗ ନାହିଁ. But this is not, there is no compromise. And also the notice was sent to these persons, my lord, these Bhagavan and then Bhagavan, Ananta and Abhay. So for this, my lord, we have filed the writ petition, my lord.
No, in the annexure 1 which you are challenging,
My lord.
In the page number 12 it is mentioned as follows.
My lord.
That
Abhay Kumar Jena and others
submitted that the required documents in connection with the payment of compensation amount, they have submitted an affidavit.
Yes,
So you are not a party to that.
No, my lord, because the case is pending, my lord. When my point is that When the case is pending, my lord,
Which case is pending?
my lord, that annexure 6, my lord, in CMA.
Lecture 6 is pending that এটা যেতବେଳେ 5/8/2024 ରେ ଏ ଅର୍ଡର ଟା ପାସ୍ କଲେ
ହଁ
ସେତେବେଳକୁ ତ କେସ୍ ପେଣ୍ଡିଂ ନଥିଲା
pending ଅଛି ଏଠି
ଆପଣ ଗୋଟେ
pending ନା ଏଟା ଏଇ ଯୋଉ annexure 6 ଟା
ହଁ
by this honorable court's order ଏଇଟା
annexure 6 ଟା କେବେ ଫାଇଲ କଲେ ଆପଣ?
6/7/23
ଆଚ୍ଛା,
presented by
okay.
stamp ଅଛି
ତାଙ୍କ
that is filed by
ତାଙ୍କ
national
ନୋଟିସ କୁ ଆଣିଥିଲେ?
yes ଆମେ ସେଟା ମତେ present ନାହୁ behind our back the petition has been filed, my lord, and the land acquisition officer has ordered this.
Page 32 mechanical plans. Page 32 order of this honorable court.
Mine.
That 3H4 as per the NH Act is initiated at the behest of the deceased mother. Their sole prayer that for apportionment there is a provision enumerated under the NH Act that is initiated under Annexure 6. When the same is pending, how the suit is maintainable? There is specific.
That is not my point, my lord. My point is that when Annexure 6 is when Annexure 6 is pending, this land acquisition officer has no power to pass such order, my lord.
No, what was your prayer in that suit?
Suit is for partition.
This is the apportionment.
Suit.
This is for apportionment of share. Whatever legal, whatever rights accrue to in favor of all the landowners, that the authority of NH Act has similar jurisdiction as the principal judge. District judge being the principal judge under NH Act. He has every jurisdiction.
No, now the order has been passed in the Annexure 1 that it has been asked to make payment of the amount to the joint accounts of Bhagwan Jena, Ananta and Abhaya.
That is the dependent number 1, 2 and 7.
This petitioner has been totally excluded.
That is the NHA one, sir.
The NHA. Yes, he has not made the NHA as a party. I said the NHA he has not made a party. When the dispute under regarding apportionment creates for jurisdiction lies to the principal civil court original jurisdiction District Jajpur. When the annexure page 32 is pending there, my lord, page 33, annexure 6.
3.
Annexure 6. Page 33. That is the application filed at the instance of the land acquisition officer. This regarding apportionment there. She should have to appear there and file a claim application that I am the entitled for regarding because I have interest in the land. That's why my apportionment shall be made. Keeping my right into consideration.
In that case, Annapurnadhar is also a party. Annapurnadhar is a party, my lord. But behind our back, my lord, the petition has been filed by one co-sharer. That is dependent number 20.
No, what is stating that CMA number 3 of 2023, when it was filed for apportionment of share, and your mother is a party, so notice must have been issued.
Yes, my lord.
This honorable directed for the matter. Page 32.
Annapurnadhar. Deceased mother. When the one initiated at the behest of the deceased mother, how can the subsequent
legal
suit file which is not maintainable because of specific bar?
Suit is a partition suit.
Annapurnadhar is the petitioner, page 32. This honorable court directed the petitioner to approach under 3HA, page 32. Para 2. Petitioner has filed the petition seeking direction to the opposite 3 to refer the LA case 4/22 to the competent civil court under 3H4 National Highway Act to resolve the dispute regarding the apportionment of the compensation amount. When once the proceeding has been initiated at the behest of deceased mother to approach the competent civil court in the district of Jajpur and matter is pending sub judice, the subsequent suit is a bar. Equal right.
No,
right
this mother is died, so you could have also prayed to be included as party in that CMA number 3 of 2020. Have you done that?
ସେଇଟା ଆଜ୍ଞା ସେଠି ମୁଁ ବୁଝିନି
ବୁଝୁନାହାନ୍ତି?
ମୁଁ ବୁଝୁଛି କିନ୍ତୁ ଆଜ୍ଞା ମୋର main prayer is that, my lord, annexure 1 ମାନେ annexure 1 ଟା ସେ କହିଲେ ଯେ defendant number 1 2 and 8 ପାଇଁକା ସେ ଦେଇଦେଲେ ପୁରା compensation amount ଟା ତାକୁ ସେ କରିଛନ୍ତି to disburse in favor of defendant number 1 2 and 8 ସେଟା ପାଇଁକା ମୋର objection ମୁଁ ଏଠି ଆସିଛି WPC
ये भी नहीं होगा and again they will be refund but because it cannot override.
ଯେ ହଉଛି ଯେତେବେଳେ ପେଣ୍ଡିଂ ଅଛି ସବୁ କେସ୍ ଏଇ ଯୋଉ annexure 6 ଟା ସେତେବେଳେ land acquisition officer has no jurisdiction to pass such type of orders behind my back and also without seeing any document. There is no such compromise and nothing else. Only by one co-shareer's petition he filed this petition matter and also the co-shareer can see there is no other person.
Whether that amount has been disbursed already.
Se je kौन discuss करते थे.
Making mention, my submission is once a reference has been made, the land acquisition should not pass this order because the principal civil court has to take a decision regarding apportionment.
So that is exactly her grievance is that.
But I take to my lord
in view of this court,
to appear there before the district judge and claim for that by filing application.
No, we do not. He has stated he has also know whether in the district judge the petitioner has filed any application to be substituted when the mother is dead.
I think they have already filed my lord.
It is better for the
ଯେତେବେଳେ ସେଟା ପେଣ୍ଡିଂ ଅଛି ସେଇ ସମୟରେ ହିଁ ସେଇଟା କରିଛନ୍ତି ଅର୍ଡର କରିଛନ୍ତି. That is my sole grievance.
Madam, I am also supporting you. You go and find the application, also make an order.
So you take instruction in that district judge court whether any such application has been made or not. You have produced this order.
Substitution application.
Yes, right.
My lord.
Lekhantu, in pursuance of the order dated 8/1/2025, the London Council for the petitioner has produced the order sheet of the London Senior Civil Judge Jashpur in CMA number 79 of 2024, which is taken on record. It appears that the petitioner earlier approached this court in WPC number 14189 of 2023 for a direction to the LAO Civil Directorate Jashpur to refer LA case number 4 of 2022 to the Principal Civil Court of Original Jurisdiction for determination of apportionment of the compensation amount due to acquisition of land for the purpose of for maintenance, management, and operation of bracketry widening oblique 2 lane with paved shoulder oblique 4 laning, etc. bracket ends NH20 in the district of Jashpur. And this court by order dated 11/5/2023 has been pleased to dispose of the writ petition directing the opposite party number 3, the land acquisition officer, to refer LA case number 4 of 2022 to the competent civil court under section 3H4 of the National Highway Act 1956 to resolve the dispute regarding apportionment of the compensation amount. The Land Council for the petitioner submitted that when the matter was sub judice, এটা referral apare in case number the matter was referred by the land acquisition officer, civil Jashpur, to the district judge Jashpur, principal, and CMA number 3 of 2023 was registered, and the mother of the petitioner Ornapurna Dhar, petitioner na petitioner?
Petitioner.
Petitioners. এটা ସମସ୍ତଙ୍କର ମା ନା legal heirs?
ହଁ ସମସ୍ତଙ୍କର ମା ଏ ପିଟିସନର ମାନଙ୍କ ମା
ଆଚ୍ଛା।
ରିଟ୍ ପିଟିସନର
The opposite party number
but 3 land
no.
acquisition officer
ଆପଣଙ୍କ ମା ଥିଲା opposite party number 1 ପରା?
ହଁ ହଁ ନାଇଁ ସେଠି ଥିଲା 1
ହଁ।
land acquisition
Opposite party number 1 in the said CMA disputed that the mother of the petitioner has already expired. When we put a pertinent question to the land and council for the petitioner as to whether any steps have been taken for substitution in the aforesaid CMA number 3 of 2023, Land Council for the petitioner seeks some time to obtain instruction in the matter. Yeah, to put up the केबे रखियो अपन
ପରଦିନ
केमती अपन ये करिवे
ଆଜି ରାତିରେ ନେଇ ଆସିବି କାରଣ ଏଠି ଅଛି ଏଠି ଲେଖା ହେଇଛି ଖାଲି
कॉपीटा बाहर करिवे ना तो कोन
ତାହେଲେ ନେକ୍ସଟ ୱିକ୍
अपन
ଥାଉ
पिटिशन अपन देइथिबे
हां
तादेरे
ନେକ୍ସଟ ୱିକ୍
this matter in week commencing from 3rd February 2025.
Madam, ଗୋଟେ କପି ଦିଅ NHA ତରଫରୁ
Let a copy be handed over to अपन कहाँ पे appear କରୁଛନ୍ତି?
ପକ୍ଷ କରିନାହାନ୍ତି ମତେ NHA
ଆଜ୍ଞା ୟୁନିୟନ ଅଫ ଇଣ୍ଡିଆ
will appear for
We are for OP number 1, yes.
copy them.
Madam,
Name of the land company requested.
annexure 1 ଟା ଅଛି
ଆସନ୍ତୁ ଆଗେ କେହି ଦେଇ ଦଉନାହାନ୍ତି ଆପଣ ଗୋଟେ ଦେଲେ ବି ଅଛି ପ୍ରୋଭିଜନ ଅଛି ଫେରେଇକିନା ଆଣିବା yes.
Item 11.
Next week, due to illness of Mr. Panda. Next week.
Just a minute. So you want adjournment?
Yes, well,
Mention is made on behalf of Mr. Pandey, Akshay Kumar Pandey for adjournment. Next week,
Next week.
list this matter in the week commencing from 3rd February 2020. We are just coming within 2 minutes. Yes.
Item 12.
May I please? State petition. The petitioner prays for a direction to the opposite party number 3 to compensate the petitioner as per law since her land is acquired for the purpose of river embankment. The act of the case is that, madam,
Your representation is pending.
representation is pending. Initially, the petitioner approached this honorable court.
Page 17.
Page 17. This while disposing by WBC number 3085 of 2023.
Yeah.
While disposing of this writ petition, this honorable court directed the opposite party to consider. And
What happened?
After that, the opposite party
Page
number
4.
3 issued a letter.
Page 4 make an
Page 4, madam.
Page 4.
25
Page 19.
2023, madam.
Annexer 4 page
Annexer
19.
4, page 19, madam.
Acha, found Allah.
25/2023. To direct the petitioner to appear before the opposite party number 3, the petitioner appear before the opposite party number 3 on the same day and file the entire document. But till now, they are not giving the compensation.
But that
Since
proof
our
is
land
not-
has already been acquired by the
Sir, he
opposite
was
party.
appeared or filed documents. That proof is not. If that is not.
So what is this application again you have filed on
Same
13/11?
On the again, well, since then they are not compensated the amount because her land has already been acquired by the opposite party number.
Let us come to Annexure 4. And Annexure 4, in pursuance of this court order, is notice was issued and you are asked to appear on 9/5/23.
Yes, sir.
So did you appear?
Appear.
And did you produce those documents, etc., whatever
Yes,
you want?
yes.
What is that averment made in the writ petition?
Para 7. Running page 5, para petition, para 7.
Yeah.
That is, you have submitted that after receiving the order of this honorable court on 2/5/2023, issued a letter to the petitioner for discussion or compliance with the order of this honorable court. And receiving the same, the petitioner appeared before the opposite party number 3 and submit the original RR copy of the letter number 2526 stated is annexed.
So thereafter, nothing has been done.
Nothing has been done.
So you obtain instruction on the matter. Click on it. This writ petition has been filed for a direction to the opposite parties to compensate the petitioner for acquisition of his or land for the construction of river embankment. It appears that the earlier the petitioner approached this court in WPC number 3085 of 2023, and by the order dated 2/3/2023, this court has been pleased to dispose of the writ petition, directing the opposite party number 3, Superintending Engineer Irrigation Division, to consider the representation filed by the petitioner and to pass appropriate order in accordance with law within a period of 3 months from the date of production of the certified copy of the order. It is the contention of the Land Council for the petitioner that after passing of such order, the petitioner was served with a notice under Annexure 4, wherein he was asked to appear in the office of the superintending engineer on 9/5/2023 for discussion. And after receiving such notice, the petitioner not only appeared before the opposite party number 3, but produced the original record of right. But thereafter, there is no further progress, and the petitioner is yet to receive the compensation amount. The Land Council led the Land Council for the state obtain instruction regarding the status of the proceeding which was initiated after receipt of the order of this court dated 2/3/2023, passed in WPC number 3085 of 2023 by the opposite party number 3, Superintending Engineer Irrigation Division. This matter will be commencing from 10th February 2025.
Next item is the same, your lordship. The lead petition number is
Next petition खाली petition number टा change करूँ इटा भी समान date राशि 10/3/2025 yes obviously
Item 14.
14 and 15 are both are similar matter. Lordship has already issued notices in two cases earlier. Okay, now fixing to third one. Regarding the system of land, the verification here they ordered the third one. I am getting necessary correction. Rate number टा देखो. जो तो जाइए 698. नहीं ये तो notice है 688. I to conclude it. ठीक है अलग तो 14 15 बहुत
एका भले order है तो
करेक्शन कर दी काउंटर पे ना काउंटर पे थर्ड मार्क
ये order correction कर दी जल्दी कर दी तो नहीं petition ना इधर सब correction कर दें और इतनी list this matter along with WPC number और 88 of 2025 कर दें सेटा भी सही order ना अन्य order
नहीं सही हाँ
Item 16.
यो 14-15 सेम तो matter
So hopefully we have given some matter to finally representation the opening side of file. The director will want to pay this Bolangir minor,
what happened to your representation
not consider my pending.
4/8/2022 এপর্যন্ত 4/8/2022 ର representative
My page 28. That's the this.
28 so this is the latest one
My lord.
what is the date of representation
2/12/22.
where is the proof that you have sent this representation
marginal left
What?
received
अच्छा,
RC
received है।
received copy 212
22/12/2024 अच्छा এটা হচ্ছে representation file is under annexure 530 page 2028 है ना it is to be disposed of on a cyclostyle order of CHANDRA তিনি মাস declare duplicate করিবে from the date of production of the certified copy and order to be communicated within 2 weeks है ना of the taking the decision लेकिन तब format के लिए पड़ेगा है ना
Left of 7.
ये
17.
next sem next time sem dispose of it
Item 18.
Next information
All the batch methods are same. The land has been given petitioner in the land outstanding.
four matters are there
4 matters.
yes any other matters pending or disposed of similar matter
Similar one is pending. It has not been listed.
acha so what is your prayer here
My lord, you will estimate on to page 21 and accept it.
21
Yes.
no
The
on
government-
please come to your prayer portion
Yes.
go not be appointed as a feeder
My first prayer, my lord. To be appointed as a fitter, JTU or the land outstay under
what
the
is what
scheme,
does mean by JOT
junior operation technique.
junior of
Operator training.
training
Training.
acha as a land outstay
Land outstay under the scheme dated 20th/7/1984. In the minutes of the meetings dated 13/3/18 and was to the advertisement in respect of serial number because the composite advertisement 2345 on the post of superintendent, JTO operators, JTO fitter, JTO electrical and JTO instruments published by code dated so and so shall not be kept in abeyance until completion of the process of giving employment to the petitioner as the NALCO ITI sponsored land outstay. The crux, my lord, 19 is so far
our land has already been acquired by the NALCO.
When?
And
When your land was acquired?
prior to 1984, that is under Annexure 1, in the year 1984, through land acquisition case number 87 by 94. 84. Under award number 3, 8, 11, 14, 18 and 23.
ଆପଣଙ୍କର 1984 ମସିହା ପୂର୍ବରୁ ଆପଣଙ୍କର ଲ୍ୟାଣ୍ଡ ଆକ୍ୱାର୍ଡ ହେଇଥିଲା
ଆଜ୍ଞା
ହେଲା
ଆଜ୍ଞା
ତ ଏ ସ୍କିମ୍ ଆସିଲା
Scheme ଆସିଲା
20/7/1984
prior to the same land has been acquired.
right so
In my
what is that
sub-
scheme?
Yes. So for the scheme is concerned, it is a scheme to provide the employment regarding the displaced persons. Where your lordship will turn to page 22. The assistance and benefit of the
2020
page 22.
yes
Keeping the broad philosophy explained in the preamble.
ଦେଖାଯାଉନି
The following type copy ଦିଆହେଇଛି
ତାପରେ
ଆଜ୍ଞା following type of assistance
wait
can-
wait wait 22 ହଁ
ଆଜ୍ଞା
22 ର କଣଟା ପଢୁଛନ୍ତି
2.1
2.1 yes
paragraph 1 define what is land displaced person.
keeping the broad
Keeping the broad philosophy explained in the preamble,
Hmm.
the following type of assistance can be extended to the local displaced person, substantial affected persons. One nominated person of each such land, displaced persons, substantial affected family will be offered employment subject to the vacancies being available, and the nominee possessing the requisite qualification skill and further subject to the conditions that the
no,
land
this policy of 1984
84
will be applicable to the lands which had already been acquired and
prior to 1984.
where is that
That
or
was
it will have a prospective operation
no, it is my lord that the first extract of the minutes of meeting on 21st board meeting held on 20th/7/1984, and the follow-up action of the meetings of the held by the Honorable Chief Minister on 17/2/1984 review the various matters related to that. Thereafter, what happened, my lord, they have sponsored our name for the ITI training under Annexure 3. Being an land outfit, provided the stipend for 1,000 for 2 years. And we have completed the examination and the course also as a fitter. And prior to 2010, Milo, the advertisement was published. Some of the land outfit, they approached this one, under Annexure 5 at page 45. This honorable court allowed the writ application, that for writ application, directed the NALCO to give the engagement, being the land outstay.
who are
Again,
those persons
that the land outstay, those who have land has been acquired,
not
they
the-
have
not
not
the- not the
provided the
petitioner.
employments. Pardon?
not the petitioner
Not the petitioners.
okay somebody else okay.
Some but 5 persons.
Ah.
Their writ application was allowed on dated 12/1/2011
yes
under Annexure 5. This honorable court order has been assailed before the Honorable Supreme. Honorable Supreme Court dismissed the writ application SLP and stated that law kept open. Thereafter, another person under Annexure 6, Govinda Chandra Naik, has approached this also. This where the advertisement of the year 2010 has been assailed. And this honorable court, relying upon the Honorable Supreme Court judgment, and framed the issues at page 70 of the brief and allowed the writ application.
okay
And since 2010 till 2024, no advertisement was published, nor they have been engaged any other persons. First, second phase has been acquired, that is, and the beneficiaries, the first batch 199, second batch 105, they have been already engaged. So far, third and fourth batch is concerned, they have not engaged because of the lack of vacancies. 2019, your lordship, the collector, district magistrate at page 77, requested the executive officer NALCO to provide the employment to these land outside. Your Lordship, on to page 80. The discussions. The collector opined that the issue providing permanent employment to the NALCO sponsored ITI lab is important, taking into consideration of the gravity of the matter. The issue should be raised before the CMD NALCO for taking appropriate decision. He requested the executive director NALCO to take steps for recruitment. The left out NALCO sponsored ITI lab at an early date. The collector advised the executive of director NALCO to look into the issue of less monthly days works to lab and request to ensure at least 26 days work per month to contractual worker lab as to prevailing laws. The collector requested the executive director NALCO to consider the gradation of semi-skilled workers to skilled workers for ITI trained labs having basing upon their one work experience. Your Lordship, in the body of the itself, that as they have not provided the employment to the land outstay as per the schemes, and so also even though they have sponsored the petitioner along with other persons for ITI, the grievance was made there. The collector has also, where the NALCO is a party to the said notes, they have not considered. Subsequently, on 20th 12/24, the advertisement was published, where the age minimum qualification and age criteria was age limit 40, where the earlier rate applications, the same age was 40 has been taken to the as a rider to the for application. That has been taken into account by this also, and although also the Honorable Supreme Court dismissed the SLP.
You are now 43.
Pardon?
You are now 43.
I am now 40. And because of the reason that the advertisement was not published since 2010 till date.
Where is that post?
Post my lord, serial number 2, 3, and 4, 5. We have for the serial number 2, superintendent JTO, sub JTO operator, sub JTO fitter, sub JTO electrical, and sub JTO instruments. I am fitter.
Fitter number 3
again. And other also, they have also qualified, and they have also paid for the
candidate must have passed 10th plus with I so and so. Acha. You have got the 10th qualification.
Yes, sir. ITI also, as per the sponsor, being a sponsor
candidate of 2 years during along with the apprenticeship one. So, what is the age factor mentioned?
There is mentioned at page 84, serial number 13.
84.
S and P complex only. That is for general candidate. But so far SAP Hon'Ble is concerned, in case candidate whose land has been acquired by NALCO project
S&P money what?
S&P complex.
In case of candidate whose lands have been acquired by
NALCO project at Hon'Ble and possess the relevant certificate issued by the land acquisition authorities of the state government in name of sale for the name of parents, grandparents, and none of their family members are employed in NALCO against the land acquired may be considered, provided he and she meets the qualification, experience, and age criteria. Minimum age limit 40 years, and the land outstay person as
if you have crossed the maximum age limit, how can you be given appointment?
My lord, because in the earlier rate applications, the said benefit has been granted. Because your lordship talked the findings of the earlier rate application.
Earlier, whether this question was raised, suppose
yes, my lord,
there was delay in the advertisement, let us say, and in that process you have crossed that age limit. You have now become 43, but they have stated that the maximum age limit is 40.
Yes,
let
that
us
question
say
has
that
been raised, but the Your Lordship, may
What is
count
the answer given by the
page 55, my lord.
55? Yes. Let us see.
The other point as to whether
Good portion.
page 55, paragraph 11.
Paragraph 11.
From. The other point as to whether the petitioner is entitled for training or not is required to be answered in favor of the petitioner for the following reason, clause 4 of the Annex of 10. Produced along with the rejoinder is so and so. Where in case of the land affected persons of SC/ST whose land have been acquired by for NALCO project and possess the relevant certificate issued by the land acquisition authority of the state government in the name of self or in the name of parents or grandparents, and none of their family members are employed in the NALCO against the land acquired, can be considered eligible. He and CSR possess past HSC examination from the state or central board, past ITI from any recognized training institute under the Directorate of Technical Education and Training, Government of Odisha in any of the trade stated above. His or her age is 40 years as on 30th 9 2008. Applications were invited by the NALCO by the prescribed qualifications of the said clause. It was decided in the proceeding held on so and so between the state authorities and the management of the NALCO, which acts not to dispute the opposite party in their counter statement. And further, same has been acted upon the NALCO by discharging its commitment in sending the petitioner to undergo the ITI training in the state-owned training institute. They shall got the training in the respective states, and they have
just focus on that age factor.
Age, my lord, that was also cut off date as on 30th 9/2008. Where
you said that in that particular case also
this advertisement has been taken into account where the age factor is a crucial point. But at point of time,
see candidate you read petitioner
that was 30 years. He was 30 years.
So how do you say? Now the thing is that you have crossed that age limit. So now the age limit is 40 as per maximum age, and you are now 43. So you cannot even apply. So what is the question of?
Well, the question is that
there is no
age limit in the minutes of meetings under Annex 2. There is no age limit has been provided for considering the benefits. And in one hand, our entire land has been taken up. And in subsequent read also, so there is no read at all.
The authority, while issuing an advertisement, they can fix what are the terms and conditions of an so that an applicant can appeal. So, can you, as an applicant, say that this particular condition should not have been there? It is like that. They say that
we are the land outstanding, and the scheme has been prepared where there is no age bar at all. There is no consideration of the age. And 2010, now it is 2024. 14 years we are agitating for the employment after completion of the course. And in the subsequent that Govinda Chandra Nay's case, though age there was no, but this honorable court also taken the note regarding the advertisement where cut-off date is 40 years. And now,
suppose let us say at that point of time, the fitter posts were not there. So that is the reason why they did not issue the advertisement. Now, when the fitter post came, they issued this advertisement. So it cannot be said that deliberately they delayed, and by that process, your maximum age limit, whatever it is,
already been over. Well, in this respect, my humble submission is that when there is no age bar in the SAP.
But that you are
Yes,
right.
my lord, they could have engaged us taking the priority being an land outstay because we have completed the course in the year 2010 or 2012 like this. And they have not considered. They have considered the candidate first phase and second phase 115 candidate and 109 candidates. Prior to 2010, when there was also they are considered not through an advertisement because being a sponsored candidate. Now here, both the rate application where 111 post has been vacant, where the cutoff date is 40.
Showing one line is there. Pardon? In that 13, there is the last sentence is very important. You are not pointing out that.
Page 30. Relaxation shall applicable to the post of SAP complex only.
So you are it is for on board.
Yes, I am. We are all for
on board.
And in the after filing mail of what development was made after filing of the writ application, the collector on board also.
No, you just read it entirely. Once again, in case
Miller.
Number
in case of the candidate whose land has been acquired for NALCO project at onboard and possess the relevant certificate issued by the land acquisition authorities of the state government in the name of self or in the name of parents or grandparents and none of their family members are employed in NALCO against the land acquired may be considered provided she meets the qualification, experience and age level. The maximum age limit is 40 years for land outstayed person as on 21st/1/25. The relaxation will be applicable for the post.
So this means this relaxation is not only for the qualification, the relaxation is for the experience, the relaxation is also for the age criteria. Right. So there lies the thing. So that 40 years, though they have fixed, that can be also relaxed in case. So in your case, that can also be relaxed if you comes within that on board that
all the persons are on board. So, but here, Miller, they have not accepted our application because the closing date, your lordship will first on to phase 1 of that advertisement.
Yes.
The
closing date is already over.
Already over. They have not accepted because we have overcome the age 40. That apart, Miller.
All right, let notice go. Let us see. This writ petition has been filed by the petitioner S.K.Sahoo Hon'Ble, who is aged about 43 years, with a prayer for his appointment as a feeder (JOT) as a land outstay under the scheme dated 27/1984 and बाकी आओ जा अच्छी से ये लिख देगा prayer portion of the land council for the petitioner placed the scheme which is annexed to the writ petition as annexure 2. What is that you
2.1 is 22 million
2.1 and in 2.1 it is held as follows 2.1 तक पूरा कोट कर दो है ना तो ये कलेक्टर ये मन थिले से कोट कितना नंबर पेज नंबर
annexure
56 में
77 पे annexure 7
annexure 7 the land council for the petitioner further drew the attention of this court to the minutes of the meeting held on 9/3/2018 under the chairmanship of the collector on board on the issue of permanent job to 198 NALCO sponsored ITI bracketary LAP families. Wherein the NALCO authorities participated and the collector opined that the issue of providing permanent employees to the NALCO sponsored ITA as bracketary LAPS is important, and taking into consideration the gravity of the matter, the issue should be raised before the CMD NALCO for taking appropriate decision. It is the contention of the learned counsel for the petitioner that in pursuance of the 4-1 notification of the government of Odisha, the land of the petitioner was acquired prior to 1984. And unanimously it was decided as per Annexure 2 that nominated person of each such land displaced person, public substance vacancies being available. And the petitioner has been nominated as one of the affected person, for which the Special Land Acquisition Officer on book intimated the petitioner to undergo admission in Basudev ITC Talche in feeder trade, and the petitioner was sponsored for ITI training under NCVT course, and he has successfully completed the same in January 2010. The Land Council submitted that this court in various writ petitions have in similar cases have allowed the prayer of the petitioners and directed the NALCO authorities to employ the petitioners of those writ petitions. And the said order was also confirmed by the Honorable Supreme Court. Is it your contention?
Yes, confirm, dismiss and let the law be kept open. That was the, I have quoted in my written.
He submitted that on subparagraph. On 2012-2024, an advertisement was issued for recruitment of non-executive posts for S&P complex Ongu and MR complex Damanjodi, and column number 3 indicates that for total number of 73 posts of SUPT GOT -FETER applications were invited. And it is mentioned therein that so far as S&P complex Angul is concerned, in case of candidates whose lands have been acquired for NALCO projects and Angul and possesses the relevant certificate issued by the land acquisition authorities of the state government in the name of self or in the name of parents or grandparents, and none of their family members are employed in NALCO against the land acquired may be considered, provided he/C meets the qualification, experience, and age criteria. Stop. The maximum age limit is 40 years for the land ousted persons as on 21/1/2025. However, the relaxation will be applicable for the posts advertised for S&P complex on good only. The Land Council for the petitioner submitted that the petitioner is coming within this clause number 13. However, since is now aged about 43 years, he could not apply in pursuance of the advertisement dated 20/12/2024. The Land Council for the petitioner submits that when the meeting was held on 9/3/2018 under the chairmanship of Collector Angul for providing employment, the NALCO sponsored ITI, no age limit was prescribed, and therefore the authorities were not proper in fixing the maximum age limit of 40 years for the land ousted persons as on 21/1/2025, which clearly runs contrary to the minutes of the meeting. Issue notice on the question of admission, indicating therein that the matter shall be disposed of at the stage of admission. Land Council for the state accepts notice on behalf of opposite party number 1, 3, 3 and 4. 4. So far as opposite party number 2, 5, 6 and 7 are concerned, panel council notice you requisites for issuance of notice by speed post with proof of delivery shall be filed within a week. Matter will be listed thereafter 4 weeks. Counter affidavit, if any, be filed in the meantime. I also issue notice except one set of process fees. You would have same matters or same order कर देंगे अलग matter है. सब उड़ा fitter तो
समस्ते fitter. Age खाली 41.
हाँ age उड़ा को 43 अच्छी on over age खाली. Okay. हाँ. All right, that's all. Next.
Pardon to mention the lordship. To the PRLM matter, your lordship. The appellant is in custody since 13 years, 6 months, your lordship.
Bail matter.
Yes, your lordship.
Is it? My lord, item 15, I pay day after tomorrow. Wait. Just
Weekly list item number 1.
video to matter. Life imprisonment. You are the prisoner's petition has come in your name. Have you filed your VNAMA? Just file it. Have you got the copy of the criminal appeal memo? So why don't you take the entire thing in your pen drive? Huh? You got the pen drive with you now? Please pass on. Ms. Rita Singh, as I pay you the prisoner's petition received from jail for engagement of Ms. Rita Singh. Ms. Rita Singh is present and she has filed the VNAMA, which is accepted. The names of other counsel shall not be reflected in the cause list henceforth. Ms. Singh submits that she is not having the appeal memo and the impugned judgment and miscases which were filed by the Land Council. Let the same be supplied by the registry to Ms. Singh in our pen drive. Name of other council other council shall not be reflected in the list. Wakalafnama is taken on record. Hard admits call for the trial court report, interim application for bail and sterilization of fine to be considered after receipt of the trial report. Yeah. They will pen drive. ठीक है.
Item 2.
There are two appeals filed by the appellants. The appellants have been convicted under section 302 and other sections, sentenced to imprisonment for life. So here, second additional session judge Raukala has convicted the appellants.
How many appellants faced trial?
Well, 6.
Accused person 6.
Yeah.
No, 5 are there.
And 1
juvenile.
Mark.
So out of these 5, all were found guilty or some?
No, only 2.
So these 2, they have filed separate appeals.
Separate.
Right. Hard admit.
One thing, I was going through the judgment.
Okay.
You will also kindly turn to page 35.
Just a minute. Call for the trial court record. Sterilization of fine. Same order in the other case.
But I have also filed an application for bail.
No, there is no bail application.
It has not come.
Mr. Mishra submits that he has filed an interim application for bail, which has been numbered as IN number
304 and 305. 304 up to 20.
But the fast rate account 1197 केते
304 of 2025.
1197 रहुची IN number 304 of 2025 IN जो CRLN number 1198 रहुची
305.
IN number 305 of 2025. The same be placed on record. The Land Council for the appellant shall hand over the deposition copies of all the witnesses examined in the trial court to the Land Council for the state in the meantime.
Okay.
Yes. Next.
Short date में kind of because
It will come in 15 days after it.
9 years in custody.
All right.
Item 3.
Claim conviction last time you also tried to file the surrender certificate. Should have filed the certificate.
Where is that?
Should have filed.
The report of the Land and Trial Court at Flag E was released on interim bail for a period of 3 months after expiry of the interim bail. He has surrendered. Period the report of the Land and Trial Court. The appellant has already surrendered after availing the interim bail period. Stop. IN number so and so. There shall be stay of realization of file pending disposal of the FGL criminal. Yes, next.
Item 4.
I would have filed Kojendi. Where is that number?
Number 24 of
Is it mean number? IN number 24 of 2025. This interim application has been filed for bail. Let a copy of the same be handed over to the Land Council for the state. The Land Council for the state shall obtain instruction regarding the conduct of the appellant while on interim bail. Put of this matter in the week commencing from 17th of February 2025. Yeah.
Item 4.
item 4 our last occasion Lordship has directed the superintendent to the accused appellant is present.
Why he was directed? Why he was directed?
My senior ତାପରେ ପୁଣି ମତେ ଦେଲା ମୁଁ ବକଲତନାମା ଫାଇଲ କଲି ତାପରେ ମୋ ବକଲତନାମାଟା ଆଉ ପ୍ରିଜନର ପିଟିସନଟା ମିସିଂ ଫ୍ରମ ରେକର୍ଡ
अच्छा
ସେ ଯୋଗୁରୁ ତାଙ୍କୁ
मिस्टर अच्छा गणेश्वर महंत राजा महंत
ଆଜ୍ଞା ସାର୍
आपण वर्तमान गोटे जेल रु गोटे दरखास्त देइथिले एवं आपण को तरफ रु वकील बाबू को अर्जित मिश्र को वकील ये करने पूर्व किंतु आपण गोटे रमणीकांत पट्टनायक जरिया केस टे फाइल करथिले वर्तमान आपण काहाकू केस दबा को चाहूचंती रमणीकांत पट्टनायक आपणर केस परिचालना करिवे ना अर्जित मिश्र करिवे काहाकू चाहूचंती
घर लोक ଦେଇଛନ୍ତି ଅଜିତ ସାର୍ କୁ
आपणकर इच्छा कोन काहाकू किए आपण केस आपण चाहूचंती सही करिवे कहंतु
କାହାକୁ ଦେବି
अरे आपण काहाकू देबे दी
ଅଜିତ
जण
ସାର୍ କୁ
दी जण जाक एडवोकेट अछंती आपण देखुचंती सामना रे छिडा आइचंती अर्जित बाबू आउ तांको साइड रे रमणीकांत पट्टनायक एसोसिएट मध्ये अछंती आपण काहाकू दबाकू चाहिले आमे तांकू ही तांको रखिबू आपण अन्य सेत पय आपण डाकितु
ସାର୍ ଅଜିତ ସାର୍ କୁ ଦେଇଛନ୍ତି ଘର ଲୋକ
अर्जित सार को देबे
ଆଜ୍ଞା
अर्जित सार को दिया जीवो तो आपण केस
ଆଜ୍ଞା
अच्छा आपण जो की अछंती जेल सेठी सुपरिटेंडेंट की अछंती सामना को आसुन हाँ सी गोटे वकालतनामा पठेइथिले अर्जित बाबू ना रे सेटा कोडी मिसप्लेस हो जाइछि आ गोटे वकालतनामा पठेइ दियंतु
ଆଜ୍ଞା ସାର୍
अछि की अछि ठीक है अछि अछि वकालतनामा दरकार
ଆଜ୍ଞା ସାର୍
फाइल कर दो अच्छा लिखुन गणेश्वर alias राजा महंत appeared from the circle jail चौद्वार कटक एटा सर्कल जेल चौद्वार तो
ଆଜ୍ଞା ସାର୍
जेल चौद्वार कटक as per the asked, stated that he wants to engage Mr. Arijit Mishra as his advocate. Mr. Mishra is present and he files the Vinama, which is accepted. The name of Mr. Mishra shall be reflected in the cause list henceforth. The name of Mr. Ramanikant Patnaik shall not be reflected in the cause list henceforth. Yes, दियंतु फाइल करंतु
Next week I ask you.
नहीं एटा दियंतु कल से मोटे नहीं
Lagi start.
लगे दिए
Counter भी.
एट दे दो ना जानी
हम दे
मु लेखिली हमर फाइल कले बेली तो
दे दो
साइज में दियो
संग संग.
सील मारी दिनी फास्ट yes next
Item 5.
I have not given the paper books and I am ready to receive today during process.
all right you have received the paper book
Nice.
huh the land council for the appellant Mr. Panda submits that he has not yet received the paper book. Let the registry supply the paper book to Mr. Panda during course of the day 80 days of the Mavigin signature. Put up this matter. You get ready. We are giving you 1 week time. Put up this matter and we commencing from 10th of February 2025. Yes, next.
Item 6.
Copy of the petition has been recorded. Case petition. Further filed within the name of the earlier transaction of the
The application of apply number 2 was allowed.
right. The number 1 has been rejected. So why it has come again? 15/1/2025.
One was rejected.
नहीं नहीं ठीक है जी 15/1/2025 रे नेम ऑफ ऑर्डर shall not be reflected. अच्छा किसी कारण नहीं आज तो लिस्ट हुआ है. Alright. Third, you are S. Samudra ना? Yes, S. Samudra. Matters will be listed in due course. Alright, next.
Item 7.
Call for the certificate notice.
Yes, Anle.
Yes, ma'am.
कितने वर्ष होती?
One of the applicants is staying at the Kendra jail and another is Champua jail.
मैं आनिचो ना नहीं ते appellant number 1 रो कितने वर्ष होला और appellant number 1 ला सत्यानंद नायक कितने वर्ष होला? और आगुर जेरोस कलेनी
Just call.
अच्छी तो अच्छी में दी अपन पार उड़े कॉपी अच्छी तो गोटे के दीटा दी जनकर अच्छी
ना
ताले अलग दी जन अलग अलग दीटा बोले
one is Champua jail and another is Kendra jail.
Custody certificate of Itala Rashanando. Rashanando Chi. Rashanando la total period kete. 3/6/22 3/6/22 ହେଲେ କେତେ ହଉଛି କେତେ ବର୍ଷ 9 ବର୍ଷ 9 ମାସ 9 years 9 months ଆରଟା ବି ସେମ୍ 9 ବର୍ଷ 8 ମାସ ଆଚ୍ଛା 3/6/8 ସେଟା ହେଲା Satyananda Naik. आगुरु बेल रिजेक्ट है नहीं?
No, my lord.
कौन तो कौन को याद है? What is the prosecution case?
Prosecution case is my lord.
Come to paragraph number 2 of the judgment.
Yes, my lord.
सेटा उठी व्यवहार करना दी सेटा काई थुआई सेटा उठी व्यवहार करंतु आपण मानन पय आछि आपण माने व्यवहार करिवेनी काई सेटा रहउछि एटी एपुडु आसुना जजमेंट रो सेकंड पेज बार प्लीज
About 19, the informal law meeting for the IC competition that on the Sunday in between 12 p.m. She admitted to jungle for collecting firewood and her husband alone at home. The accused persons, namely Balaram Naik and his two sons, namely Satyam Naik and Prasanta Naik, came and assaulted her.
What is the name of the deceased?
It is my lord.
Huh?
Prasanta Naik.
Dushasan Naik. Date of occurrence होची 19 to 2015. Okay. हाँ पढ़ंदु.
The accused person, namely Balaram Naik and his sons, Satyam Naik and Prasanta Naik, came and assaulted her husband by means of an axe, politician, etc., causing severe bleeding injuries on his head and other part of the body with full blood from its nose and mouth. Her daughter Rekha Naik, PW2, nice Andra Naik, PW3, saw the incident. Believing her husband died, they left the place administrating.
So there are eyewitnesses to there. Who are the eyewitnesses?
2 and 3 members.
PW2 and PW3. 2 and 3. They are the daughters of the deceased.
One is daughter and niece.
Acha. And who is the doctor conducted PM?
Doctor is my PW 26.
PW 26. Okay. What you come to one eyewitness PW2?
Yes,
Rekha.
my mother is father. I know all the information having the duck. From the 2 years back, the incident took place in front of my house on Village Road on the daytime. I, along with my cousin sister, Indira, was present inside the house. I gave rise to my father after taking the milk. My father went outside the house. The accused Rasananda Sutanda were coming on the village road, holding a bamboo bundle and kept in the cow shed. Thereafter, the accused Rasananda holding a Vidya and the accused Balrama holding a spade. The accused Satyananda holding stick and stone pieces assaulted my father, causing injury on his head and neck.
So just a minute. Satyananda hella brick.
Yes, madam.
Balaram hella spade. Rashananda there accused nahi. Huh? ये तीन जन परा एठी हला आपनकर जजमेंट रे दी जन करना अछि
Did appeal filed. Sir, father is already appeal is expired.
ओ अच्छा
Balrama is expired. Father and two sons are expired.
हां
Father already expired. Another appeal made.
ओ रसानंद इज एक्सपायर्ड
Balrama expired.
बापा ना कोन
Balrama.
ओ बाप अच्छा बलराम रो दी पुओ त माने गोटे होउची रसानंद सत्यानंद आ गोटे होउची रसानंद अच्छा आ बलराम एक्सपायर्ड कर जाई ओके ताले एठी जो दीटा अछंती वर्तमान ये रसानंद पड़ुची बुडिया All right. And then they was assaulted, profuse bleeding. All the accused persons left. So that is the evidence. What about the other eyewitness? Same.
No, my lord, there is no
PW3.
Nityananda assaulted the deceased by means of
अच्छा सत्यानंद सिंह कहला ब्रिक ये करची पेला बुडिया तापर बलराम कहला स्पेट बलराम स्पेट टा अछि
कुछ रसम द ग्रेटेस्ट स्टूडेंट ब्रिक में
अच्छा
so I will think other section of it. First there is a period 24 I mind.
cross examination of iota is PW 27 24 हाँ वो पेज कितना पैराग्राफ
Paragraph 5 mind. 5 and 6.
discrepancy pointed out urgently. The fact that PW2 has stated before me that her sister went to the jungle to call her accused Rasanam assaulted by Udia. Satyananda by means of a brick and stone pieces. PW3 has not stated before me. The incident took place on the original. So, what the doctor has noticed, PW26, there are number of injuries, contusions, speech wounds, fracture over the left parietal region, tracking from Swan to vortex area.
No, in 6
Again, fracture on the right temporal region, extradural hemorrhage achieved right temporal region.
So this discovery is nature and could have been caused by hard and blood test infected receptacle. So 11. Which could have been caused by the tail mind for the breast.
What do you say, Mr. Pradhan? କହୁଛନ୍ତି ତିନି ଜଣ assault କଲେ ବୋଲି ଅଛି ବାପା ଦି ପୁଅ ବାପା ତ ମରିଗଲେଣି ବାକି ଦି ପୁଅ ଏଇ ଯୋଉ ରହିଛନ୍ତି so far as Satyananda Naik is concerned PW2 କହୁଛି ଯେ brick ରେ ମାରଲା ତାକୁ whereas PW3 କହୁଛି ବୁଡିଆରେ ମାରଲା ଆଉ ବାକି ରସାନନ୍ଦ ତାକା ବୁଡିଆରେ ମାରଲା ବୋଲି କହୁଛି PW2. What about PW3? PW3 कौची रसायन तू stone ने मारला stone and brick. So many injuries are. नहीं आपनकर दीटा तो आई विटनेस ना दीटा विटनेस रो वर्सन टा टैली करूनी ये जो दीटा accused ले ଆପଣଙ୍କର ସତ୍ୟାନନ୍ଦ କୁ ଜଣେ ୱିଟନେସ୍ କହିଲା ବ୍ରିକ୍ ରେ ମାରଲା ତ ଆର ଜଣକ କହୁଛି ସତ୍ୟାନନ୍ଦ ବୁଡିଆରେ ମାରଲା ସେମିତି ଯୋଉ ରସାନନ୍ଦ ଜଣେ କହୁଛି ବୁଡିଆରେ ମାରଲା PW2 ଆର ଜଣ କହୁଛି ଷ୍ଟୋନ୍ ଆଉ ବ୍ରିକ୍ ରେ ମାରଲା ଏଇ ଟାଇପ ର ଡିସ୍କ୍ରିପାନ୍ସି ଅଛି ବାକି apart from that they have remained in custody for more than 9 years ହେଲା ଆଉ doctor of course has noticed number of injuries but he has stated that the main injury which has caused death they are craniocerebral injury sustained at its complication there that is there. There is an appeal of the year 2018 and paper book has not been prepared also. So it may take many years for preparation and for hearing. Are the learned counsel for the petitioners, learned counsel for the state, learned counsel for the petitioner submits that the petitioner appellant number 1 hyphen petitioner Satyananda Nayak is in judicial custody for 9 years 8 months and appellant number 2 petitioner Rashananda Nayak is in judicial custody for 9 years 9 months and the learning council for the state has also produced the custody certificate of the petitioners, which also fortifies the submission made by the land council for the appellant, and the custody certificates are taken on record. The land council submits that the two appellants, along with their father, Balram Nayak, Space Prior, under section 302 by 506, read section 34 of the Indian Penal Code, and all of them were found guilty under section 302 by 34, though they were acquitted of the charge under section 506 by 34 of the Indian Penal Code. The father of the appellants is now dead. The conviction of the appellants is mainly based on the evidence of two eyewitnesses, that is PW2 and PW3, and they are related to the deceased Dushasan Nayak, and so far as PW2 is concerned, though he stated that the appellant number 1 petitioner Satyananda Nayak assaulted the deceased by means of a brick, the PW3 has stated that appellant used budia in assaulting the deceased. Similarly, so far as appellant number 2 Prashanam Nayak is concerned, though PW2 has stated that the said appellant used budia in assaulting the deceased, whereas PW3 has stated that appellant number 2 used stone and brick in assaulting the deceased. It stated that in view of the discrepancies in the evidence of two eyewitnesses relating to the weapons used by the appellants in assaulting the deceased, there are good chances of success in the appeal. He further submits that the paper book has not been prepared and there is no chance of early hearing, and therefore the bail application may be favorably considered. Learned counsel for the state opposed the prayer for bail, placed the evidence of PW2 and PW3, so also the doctor who conducted post-mortem examination, Dr. Bracketal example, PW26, who conducted post-mortem examination and stated that the cause of death was due to craniocerebral injury sustained and its complications thereof. Considering the submission made by the learned counsel for the respective parties, nature of evidence adduced by the two eyewitnesses, period of detention of the petitioners in judicial custody, absence of any chance of early hearing, we are inclined to release the petitioners on bail allowed.
Item 8.
What report? We use the report of the London trial court at flag A. If it appeared that after availing the interim bail period, the appellant has surrendered. Yes, next.
Item 9.
Custody certificate.
I am for applicant number.
Just a minute.
I ordered to 16/1/25 directed for production of the custody certificate. For the custody certificate, respect only appellant number 1.
No, Mr. Panda placed for appellant number 2 only. So have you not obtained the appellant number 2?
They have only sent the in respect of appellant number 1. There should be kindly proceed to tomorrow and get the one.
Who jail achandi?
Venkana.
Why per you kali for?
Or at best day after tomorrow.
Day after tomorrow, that would be better. The London Council for the State has produced the custody certificate of appellant number 1, Pramod Sahu. However, submits that the matter may be taken up day after tomorrow, so that he will produce the custody certificate of appellant number 2, Babuli Sahu, put up this matter on 29th of January 2025.
Item 10.
Regional petition.
Where is the prisoner's petition? This prisoner's petition has been received for engagement of so and so to conduct the case on okay. In this country, so and so has filed Lena which is referred. So you are to conduct the pressure. You want to place this bail application today?
Yes,
Or let's place it.
Yeah, I know. Paper book may be supplied to me so that I can
Paper book has been
prepare.
prepared. All right.
Jail
Have you received the paper book?
No, my lord, I have not.
Have you received it? Since Mr. Sapan Kumar Pal has been engaged in this case to argue the jail criminal appeal on the basis of prisoner's petition, the name of the other counsel shall not be reflected in the cause list henceforth. Stop. Both the learned counsel submit that since paper books have already been prepared, they may be supplied with a copy of the paper book. Let the registry supply the copy of the paper book to the learned counsel for the appellant, so also the learned counsel for the state. ଏଟାକୁ ଦେଇ ଦିଅନ୍ତୁ ଆଜି ତାଙ୍କର signature ନେଇଯିବେ ହେଲା. Yes.
I have pressed bail application on today, my lord. I have pressed bail.
Let him go through that paper book. It will come. Yes, he has not gone through the paper book and not the evidence also. So, jail criminal appeal will come next week, 3rd of February 2025.
Item 11,
12/24 orderly guidelines. 2424. Submitted by Mr. Patnaik so and so on being released on interim bail right so and so on. The appellant has not surrendered on the date fixed. As on to take for this matter. କଣ ହେଲା ତାର ଜଲ୍ଦି ଆରେଷ୍ଟ କଲାଣି ନା ନାଇଁ ସେମିତି ରହିଛି NBW ସେମିତି ରହିଛି ଆପଣଙ୍କୁ କୁହାଯାଇଥିଲା ଇନଷ୍ଟ୍ରକ୍ସନ ଆଣିବାକୁ ନା ଆଚ୍ଛା the learning counsel for the state submitted that he is yet to obtain instruction regarding the arrest of the appellant. Stop. The learning trial courts are also submit a report to this court as soon as the appellant is taken into judicial custody. Copy of the order be communicated to the learning trial court for compliance. Matter be listed after 2 issued date date.
item 12,
Well, bail her husband in 302 and 492. Just pray 2-3 days time maybe I'm not prepared and taken up on 3rd of February.
Paper book ପାଇଯାଇଛନ୍ତି
Paper book
ଆପଣ ପାଇଛନ୍ତି ପାପର ହେଇଯାଇଛି
paper book ହେଇଛି.
ନେଇଯାଉନାହାନ୍ତି the learning counsel for the appellants also the learning counsel for the state submits that they have not received the copy of the paper book. Let the registry supply copy of the paper book to the learning counsel for the appellants who also sponsor ଆଜି ହିଁ ଦେଇଦିଅନ୍ତୁ ହେଲା ଆର ସପ୍ତାହରେ ନେବା matter be listed in the week commencing from 3/2/2024.
He was granted interim bail for certain
For
period.
consideration of the bail application. Yes, next.
item 13,
May it please your lordships. On item 13, I have on VC your lordships, I have not received the copy of the paper books your lordships.
ଆଉ ପଠାନ୍ତୁ ନା ଆପଣ ଆସି ନେବେ
I'll send someone to receive it, your lordships.
Miss Profusa Naidu, Land Council submits that she is yet to receive the copy of the paper book. Let the registry supply the copy of the paper book. ଯେହେତୁ ଆପଣଙ୍କର ନାଁ ଅଛି ଏଟା ଜେଲ କ୍ରିମିନାଲ ଅପିଲଟା ତ
Your lordships, I was engaged your lordships by order dated 1/7/2024.
ମାନେ ଆପଣ ନିଜେ ଆସିକିନି ନେଇଯାଆନ୍ତୁ ସେ ଅନ୍ୟ ତାର ପାୱାର ନାହିଁ ତ
I'll come and receive your lordships.
Yes, next.
item 14,
Yes, where is Miss Mehta?
My lord, in this case, last occasion, my lord directed State Council to obtain instruction. For the portion of the record of ANANDA, no such letter has been issued to the jail operative to obtain the
Where is Miss Mehta? It's Dilebra. What for you?
what is the time monitoring registration time?
नहीं এটা 302 কেস তো
Yes.
302 କେସ୍ ରେ ଇଏ ହେଲା ଯେ ସେଗୁଡାକ 10 years practice ନହେଲେ engage କରିବେ ନାହିଁ ବୋଲି ମିସ୍ ମେଟାଙ୍କର 10 years practice amicus curiae ଯେ ତାଙ୍କୁ ବି 10 years ନହେଲେ ଦେଇ ହବନି High Court ଆଉ death sentence ଗୁଡାକ decision ଆସିଛି 10 years minimum practice is necessary. I don't think that she is having 10 years of practice. I'm sure. Who is having 10 years of practice can only be engaged. We are not doubting about her competency, but because of the Supreme Court decision that somebody who is having 10 years of practice is to be engaged as the amicus curiae in such matter. So therefore, we are to engage somebody else.
Can it be taken so that we can be
whether ତାଙ୍କର ବି ହେଇନଥିବ ଇଏ ମିଷ୍ଟର ପଣ୍ଡାର ଜୁନିୟର ପଣ୍ଡାଙ୍କ ତାଙ୍କର 10 years of practice ନା ନା ହେଇନଥିବ all right this will be taken up tomorrow as prayed for by so and so you find out that decision of 10 years Justice Lalit's decision is there Supreme Court decision but at least 10 years practice would be necessary. Miss Mehta, we are asking you that how many years of practice you are. You are 2021. So the problem is that the Supreme Court decision says that you are to having 10 years of practice. Are you aware about that decision? So that is the problem. We say that cannot be engaged as the amicus curiae to conduct the case because of the base number of we know that we can well but the thing is that in view of this problem even name
Mr. S.K.Sahoo
नहीं तांकु पछो see you give the preference upon 10 years of practice Mr. Panda are you have I could disengage in view of the less number of only 3 years of practice, and so on. So who is having this much? Jaro debbe taro tike enrollment number ta debe. They debe court master को देले से engage करे, है ना? Yes.
check कर देगी
Yes, anybody is ready now. that matter cannot be taken up today. It can be taken up tomorrow, right? Because it's a part-hard matter.
If my notice is
Can-
not
can-
item 18
Can it be finished today?
Yes.
Your item number is 18.
18, sir.
18 number କାହାକୁ ଦେଇଛନ୍ତି କରିବା ପାଇଁ? ଆପଣ କରିବେ?
Please, madam. My lord, here, the appellant is also languishing in jail custody since 26/9/2000.
How many appellants are there?
Only single appellant, solitary appellant is there. And allegation of.
Just
Sir,
a person faced trial
yes,
and he has been found guilty under section.
302,
You come to the FIR.
sir. Initially, FIR has been registered under section 326 and
Just
307.
a minute. ପଢନ୍ତୁ FIR ଟା ପଢନ୍ତୁ. Page number 35. Here.
पूरा नाम बीरेन दीपा.
Biren Deep is PW.
PW1. He is the informant as well as the stated to be the eyewitness.
Okay.
पिता सुदर्शन दीपा, ग्राम हरिजन साई, महिबाल थाना बौद्ध. लिखी देबा रिपोर्ट एई जे आज अर्थात 26/6/2009 तारीख समय प्राय 6 घंटा समय मु आम घर आगे थी एई समय आम गाँव रमेश प्रधान actually sorry no रमेश प्रधान this is
Ramesh, just a minute. Don't be hasty.
no sir Ramesh Pradhan is the father, he is the deceased.
Ramesh Pradhan is the deceased.
Deceased, sir. That is the allegation of patricide.
Ramesh Pradhan को Sugyan Pradhan.
Sugyan Pradhan is the appellant.
Sugyan Pradhan is the appellant.
ଓ ସାନ ପୁଅ ସୁଜ୍ଞାନ ପ୍ରଧାନ ହଳ ବଳଦ ନେଇ ଯାଉଥିଲା, ତାର ପଛେ ପଛେ ତାର ବାପା ରମେଶ ପ୍ରଧାନ ଆସି ହଳ ବଳଦ ଛଡାଇ ନେଲେ। ସେଠୁ ସୁଜ୍ଞାନ ପ୍ରଧାନ ତାର ବାପାର ପଛେ ପଛେ ଆସି ଜୀବନ ମାରିଦେବା ପାଇଁ ତାର ମୁଣ୍ଡକୁ ଲକ୍ଷ୍ୟ କରି ଟାଙ୍ଗିଆ ଚୁଟ ମାରିଲା। ରମେଶ ପ୍ରଧାନ ରୋଡ ଉପରେ ପଡିଯିବାରୁ ତାର ବେକକୁ ପୁଣି ସୁଜ୍ଞାନ ପ୍ରଧାନ ଟାଙ୍ଗିଆରେ ଆଣିଦେଲା। ମୁଁ ଦୌଡ଼ି ଯାଇ ଅଟକାଇବାରୁ ମୋତେ ଟାଙ୍ଗିଆରେ ଦେଖାଇ ମୁଁ ସେଠାରୁ ଗାଁକୁ ଦୌଡ଼ି ଯାଇ ତାଙ୍କର ଘରକୁ ଯାଇ ଖବର ଦେଲି। ମୁଁ ଓ ରମେଶ ବଡ଼ ପୁଅକୁ ଗୁରୁତର ଅବସ୍ଥାରେ ସେଠାରୁ ଉଠାଇ ଫୁଲବାଣୀ ମେଡିକାଲ ନେଲୁ। ଆମକୁ ଦେଖି ସୁଜ୍ଞାନ ଟାଙ୍ଗିଆ ଧରି ଲକ୍ଷ୍ମୀ ନାଳ ଆଡେ ଦୌଡ଼ି ପଳାଇଗଲା। ଏଣୁ ମୁଁ ଏହା ଲେଖି ଦେଉଅଛି ଯେ ଏହାର ତଦନ୍ତ କରାଯାଉ।
Okay, so he is the only eyewitness.
No. PW1 the informant.
Just a minute.
Sir.
Let us see.
And PW7 is there.
Just a minute. So deceased hala
Ramesh
Pradhan and date of occurrence hala
26/6/2009.
26/6/2009.
Yes.
So who are the eyewitnesses to the
PW1 and PW7.
PW1 and PW7.
7.
Who is the doctor who has conducted PM?
PW11 and 12, but PW12 is the doctor.
Who has conducted PM?
Yes, PW12.
PW12. Okay, now you come to the evidence of PW1, the eyewitness. So that is the only charge which you face.
Yes.
302.
302.
No other charge.
No.
No, you are not correct. Please come to the charge, page number 39.
Sir. Shri B. Toro, LLM and Science. Firstly, that you on or about 26/6/2009 at about 6 a.m. at Mohibahala Horizon site committed murder by intentionally, knowingly causing the death of Ramesh Pradhan and thereby committed an offence punishable under section 302 of the Indian Penal Code with cognizance of our.
All right, so 302 is there, 506 is there, 201 is there. ଏଇଥିପାଇଁ ପଚାରୁଛୁ ଆପଣଙ୍କୁ 302 ନା ଆଉ କଣ ଆପଣଙ୍କୁ ନାହିଁ ଖାଲି 302
conviction is only made on 302.
ଆପଣଙ୍କୁ ପଚାରିଲୁ ସେଇଆ ପ୍ରଶ୍ନ ପଚାରିଲୁ ଚାର୍ଜ କୋଉଥିରେ ହେଇଥିଲା yes now come to PW1 ଆଉ ଏଇ ଦିଟା ଆଇ ୱିଟନେସ୍ ବୋଲି ସିଓର ନା ଆଉ ପୁଣି
No, three also another. No, 3, 5 and 6 they have been disbelieved. Though they are stated with the evidence, they have disbelieved by the ordinance tribunal.
Right, we'll go by PW1.
Once. Yes. I know the accused, Sugyani Pradhan. Now, around 1 year back, the deceased had been killed in front of my house by this accused. On the fateful day, early morning, I was present in front of my house. At that time, I noticed that while the deceased was passing through the front of my house, this accused suddenly dealt a blow by means of tangia on the head of the deceased. Noticing this, I interfered and asked the accused as to why he was inflicted tangia blow on the deceased. Then I rushed into the village and informed the matter to Vijnana Pradhan, the son of the deceased.
Who is Vijnana Pradhan? PW?
Vijnana Pradhan is the PW3.
Second one.
Sir.
ତରତର ହୁଅନ୍ତୁନି ଆମେ ପ୍ରଶ୍ନ ପଚାରୁଛୁ ସଠିକ ଉତ୍ତର ଦିଅ
Schedule 5 is the Vijnana. Sir, Vijnana Pradhan is the 5.
ଏଟା କଣ ରିଟ୍ ଆର୍ଗୁମେଣ୍ଟ କରୁଛନ୍ତି ନା କଣ? Yes, PW5.
PW5, sir. PW5.
Next.
PW5. Yes.
Next paragraph.
Sir.
Please paragraph number 3.
Sir. On the same day, around noon, I informed the matter at the PS. At PS, someone also scribed my report as per my version. Then I affixing my of nature, and amongst them there was one Ravi Pradhan and one Nava Pradhan. At that time, the infliction of the blow on the deceased, none of them had rushed to this spot, but later many persons gathered there. I cannot say exactly as to particularly who had so scribed my report at the PS. It is a fact that I do not know the scribe wrote on my FIR. There is no person in my village named as Lakshman Deepa. It is not a fact that the accused had never inflicted any tangia blow on the person of the deceased, and that in connivance with the other and the police had falsely implicated the accused on the subject. May I draw my lordship's attention to PW3.
ଏଇ ୱିଟନେସ୍ ଉପରେ ଆପଣଙ୍କର କଣ କହିବାର ଅଛି?
Yes, PW3 sir.
ମୁଁ ଆପଣଙ୍କୁ ପଚାରୁଛି ଏଇ ୱିଟନେସ୍ ଉପରେ ଆପଣଙ୍କର କଣ କହିବାର ଅଛି?
Because it is stated by the PW3 that there was a darkness. No one has seen the occurrence. That is admitted by the PW3. PW3 is one of the son of the deceased. He said it is a darkness, and also the PW3 says that no one present in the at this spot. May I draw my lordship's attention to PW3 sir.
ସକାଳେ ଘଟଣା ହଉଛି
Dawn time 5 to 5:30.
Month of June.
ଚିହ୍ନା ଲୋକ ଗାଁ ଲୋକ
ଆଜ୍ଞା
ତାଙ୍କ ଘର ସାମ୍ନାରେ ଘଟଣା ହଉଛି ତ ଆଇଡେଣ୍ଟିଫିକେସନ ରେ କଣ ପ୍ରୋବ୍ଲେମ ଆସିବ? ଆପଣଙ୍କ ବସ୍ତିର ଯେତିକ ଲୋକ ଆପଣଙ୍କ ଘର ପାଖ ଦେଇ ଗଲା ପରେ ଆପଣ ଚିହ୍ନିବାରେ ଭୁଲଭାଲ କରିବେ କି ସକାଳେ ଗଲେ ବୋଲି? କୋଉଠି ହେଇଥିବ
other PW they are saying that no one present at this spot. That is the PW3. His son said, sir, PW3. I know the accused. He is the Ravi Pradhan.
So a witness ଉପରେ ଆପଣଙ୍କର କିଛି କହିବାର ନାହିଁ except that in view of PW3
it is
He has not
doubtful.
only I said that he has not seen the occurrence because the assault part, the assault made by the accused on the deceased is not described by the PW1. That means he does not know. He has not seen the occurrence because there is other stated that there was an enmity between the appellant with
Just take. So, Mr. Nayak, so far as this witness is concerned, as it appears from the chief examination, he has seen only one blow. Just go through again, chief examination. This accused suddenly dealt a blow by means of a tangia on the head. Thereafter, ସେ ପଚାରିଲା ଯେ କାହିଁକି ତମେ ଇଏ ଦେଲ ତାପରେ ଗାଁକୁ ପଳେଇଲା ତେଣୁ ସିଏ ଗୋଟିଏ ବ୍ଲୋ ଦେଖିଛି କୋଉଥିରେ ନା ଟାଙ୍ଗିଆରେ ମୁଣ୍ଡକୁ ଦବା. Now, if you come to the paragraph number 5, last sentence.
I have not
marked as to where on the person of the deceased the axe blow hit. That means the statement that it was hit on the head is doubtful because he has not himself seen as to which portion that axe hit. Chief re कहला मुंडू को मारला, cross examination ने कहला से blow टा कोठी पड़िला मु कहि परिबे. So this is kind of discrepancy. Now, second thing, it appears that he is the informant, but he is not aware as to who has scribed the FIR. So whether your scribe of the FIR has been examined in this case.
Yes, Mr.
Who is that scribe? PW2. PW2 has scribed the FIR. Just a minute. Now you come to the evidence of PW2.
Sir.
Who has scribed the FIR.
I know PW1.
Yeah.
His name is Babuli Kohoro. I know PW1 of the case. Around 1 year back, on one noon time, he coming to the PS, informed about the attack on the deceased of this case by the accused with a tangia in front of his house. When the IIC directed him to give the written, give the writing, he expressed his inability to do so, being himself illiterate. Therefore, at the instance of the IIC, I scribed the version of PW1 as he narrated in a piece of paper and simultaneously read over and explained the same to him. Thereafter, he affixes the LPI. Thereon, I have given my endorsement with the signature. Thereon, as the scribe thereof, this is the said FIR of the PW1 scribed by me, now marked as Exhibit 1 and Exhibit 1 by 1 also, marked now in my endorsement with signature thereon as the scribe thereof. In cross-examination, he say, I know PW1 as because his father is also a grammar-okhi in my PS. PW1 is very well known to me. On Exhibit 1, I have given no specific endorsement to the effect that after scribing it, I have read over and explained the same to PW1. I cannot say the exact calendar date and month of that incident. It is not a fact that the contents of Exhibit 1 are not the version of PW1 and that it, at the instance of IIC, I and of my opinion, accord had scribed Exhibit 1 is mine the language dictated and accorded by me.
So even in page number 36 of the FIR, ଏଠି ଲେଖା ହେଇଛି ଲେଖକ ହଉଛନ୍ତି ଗ୍ରାମରକ୍ଷୀ ବାବୁଲି କୁଆଁର. Page number 36 is PW2. Right. And of course, it is right that neither in the PW1 has stated that after writing the written report, it was read over and explained to me by the scribe, nor there is also any such endorsement in that FIR. Now you come to PW3.
Sir, PW3, Ravi Pradhan.
Yeah.
Yes. I know the accused, Sugyani Pradhan, now standing in the dock and swore to his father the deceased of this case. Around 1 year back, on one early morning, this accused killed his father, deceased, by inflicting Tangia blow in front of the house of PW1. At the relevant time, I was attending the call of nature at a distance of about 200 cubits away from the spot, and therefrom I witnessed the incident. Nothing this incident.
Noticing this.
Noticing this incident, I went to my house instead of going to the spot. The accused also simultaneously stayed away from the spot.
This witness has been disbelieved by the trial court.
3, 4, 5, 6 all are disbelieved by the
trial court finding. PW3 raw evidence.
3, 5 and 6.
PW3 raw evidence both he discussed disbelief. That is in page number 14, 15, 16. Internal page is 12, 13, 14.
Internal page is 2019.
PW1. PW3 of one. PW3
stated that from the above fact which are interlinked to each other as well as with the testimony of PW1, 3, 5 and 6, 5, 6 and 7, it is indicative of the fact that on the morning the accused had attacked Mrs. Tangia from the
PW3 could disbelieve.
Sir. Yes, either. The fact on that morning.
Page
21. Page 21.
Page 21
Sir. Yes.
Could lekha
18. So from the above fact which are interlinked to each other as well as with the testimony of PW1, 3, 5, 6 and 7, it is indicative of the fact that on the morning the accused had attacked the deceased by Tangia from the testimony of PW. Sir, PW7 also nothing implicable or improbable would be gathered in view of the testimony with the suspicion. In addition to the above finding, the evidence of some witnesses are to be considered from the other. Page para 11. From the testimony of PW1 and PW7, it is already noted that they have seen the dealing of Tangia blows on the person of the deceased by accused. The other witnesses, see PW3, 5 and 6 reflect that they have not seen the actual dealing of the blows by any Tangia on the person of the deceased, but all of them have added that at that time while they rushed toward the spot hearing the holla, not only they found the deceased was lying injured in a pool of blood, but simultaneously at the time they found the accused was running away from the spot.
So they have not been totally disbelieved. They have been disbelieved. Their evidence has not been accepted as the actual witness to the actual assault.
Yes.
But they have regarding the part that you were seen fleeing away from the spot and the deceased was lying. This is one of the factor which on which they have adduced the evidence, and that has also been accepted by the London trial court apart from the evidence of PW1 and PW7, right? Yes. Now you come to the PW3. You have 43 paragraph cross-examination question.
Cross-examination. At the relevant time of the incident, there was a slight darkness
At that time, I have seen none else in the near vicinity. So I cannot say as to on which portion of the body of the deceased and how many blows were inflicted by this accused. It is not a
You
fact that.
see, Mr. Panda,
Sir,
the persons are standing at different places. They are watching the occurrence. So one might not be noticing the presence of others, because once they hear the sound, their attention would be diverted to the place of assault, who was assaulted, and who were standing there at what point of time, that might be missing their notice. So that does not mean that nobody was. That would clearly rule out the presence of the other witness.
but there admittedly there was a darkness, sir.
It is not dark, it is a slight
Slight
darkness,
darkness.
but the persons are all the co-villagers.
Yes.
ଏମାନେ ସମସ୍ତେ ସେଇ ଗାଁର ଲୋକ ଏବଂ ତାଙ୍କ ଘର ପାଖାପାଖି ଇଏ ଆଟେଣ୍ଡ କରିବାକୁ ଯାଇଛି କଲ୍ ଅଫ୍ ନେଚର, କାହା ଘର ସାମ୍ନାରେ ଘଟଣା ହଉଛି, ତେଣୁ ଖରାଦିନ ଟିକେ ସକାଳୁ ଘଟଣାଟା ହେଇଛି। ଆଉ ଓବିୟସଲି ଖରାଦିନେ ପ୍ରାୟ 5:30 ଭିତରେ ମଧ୍ୟ ଲାଇଟ୍ ପଳେଇ ଆସେ, ତେଣୁ ଭିଜିବିଲିଟି ଫ୍ୟାକ୍ଟର ଗୋଟେ ଗ୍ରାଉଣ୍ଡ ନୁହେଁ ଯେ ଜଣକୁ ଡିସବିଲିଭ କରିବା, ମାନେ ଏଇ ଗ୍ରାଉଣ୍ଡରେ, କାରଣ ଟାଇମ ଅଫ ଅକରେନ୍ସ ହଉଛି 6ଟା। Okay, next witness.
PW sir, PW4. I know that you now standing on the dock. I have gathered from the village Lucia that around 1 year back this accused inflicted in Tangia blow killed his father during the course of
I
investigation.
have gathered from the village gossip that about 1 year back this accused a child. ତାପରେ ହେଲା ଯୋଉ seizure
During course of investigation, police seized the weapon of offense which is a Tangia and also some bloods, but that is the bloods over the blood stain is stated. Police say no, there was no blood there. Blood stain.
Okay, you come to the next one, PW5.
Sir, PW5. The accused now standing on the dock is my own younger brother, while the deceased is my father. Around 1 year back, on one early morning, this accused murdered the deceased at the relevant time. I was sleeping in my house. At that time, one Biren Dipa means the informant, who is also the son. Yeah, is the son of our village Gramaraki, came to my house and informed that this accused has inflicted Tangia blows on my father and has killed him in front of his Birendipa house. So I rushed to the spot and found that my father was lying in a pool of blood in front of the house of Birendipa. I found cut injuries on his neck, beside backside of the head and on his back. So I myself, with the help of one Sushil Pradhan, Rajendra Pradhan, Pramila Pradhan, it is immediately shifted my father to Fulbani Hospital.
How many blows you have given to your father? See the evidence of PW12, page number 77. This PW1 no doubt has seen only one blow, thereafter left the spot. But the other witness, PW7, he has also stated that the deceased was lying down. PW7's evidence.
Yes.
I noticed the deceased was lying down and the accused was inflicting Tangia blows on his so-and-so. I shouted so-and-so. And see the blows, number of blows have been given.
This was not died down the very day. He was shifted to Fulbani Hospital, then he was shifted to the MKC Hospital, Vanapur, thereafter shifted to the SCV Medical College, Kotak. In the next day, he was died.
That does not mean that the type of blows you have given, you see, number 1 is on the scalp.
And that part also, there was no enmity between the father and son. Previously, there was no enmity because all the sons they are staying separately from each other.
There was second blow is also on the scalp. Third blow is also on the scalp. Fourth blow is also on the scalp. Fifth blow is also on the scalp. Sixth is left supraclavicular fossa. Seventh blow, all the incised wound. On the left side, back of the chest, 8 incised wounds. On the right side chest, 9 incised wounds. On the left shoulder, 10 lacerated wound.
Left ear.
On the ear, then apart from that, multiple abrasions are there. And internal injury, there was contusion of undersurface of the skull. On the left parietal area, there was fracture of skull at the right parietal eminence corresponding to external injury number 1. Then there was cord fracture of the skull. The above cord fracture so and so. Then dura was caught underneath the fractured skull so and so. Presence of extradural hemorrhage. There was thin layer of so and so. There was presence of multiple hemorrhages in the vital part of the brain. So I have come to this so and so external injury 1 to 9, and the corresponding internal injuries were antemortem in nature, caused by moderately heavy to heavy cutting weapon. External injury number 10, 11, 12 where antemortem might have been caused by hard and blunt. 3. External injury number 1 and 2 corresponding to internal injury are individually as well as collectively fatal in ordinary course of nature. Death was due to intracranial hemorrhage. Age of the injury so and so, so and so. So you are the person who, being the son of the deceased, you assaulted your father mercilessly even when she was lying on the ground, and your blows are, most of the blows are aimed at the scalp, and that resulted fracture of the skull bone and hematoma, and ultimately he died. So how do you say that this case should not be under 302 and it would be a...
Due to spur of a moment, the incident also occurred. There was no enmity, prior enmity between the father and son. They having a very good relationship. Because maybe
very good relationship.
Maybe because out of out of the financial crisis, he wanted to.
No, don't. Have you brought out anything? How the occurrence took place, or
because the accused also taking the plow, this auction to sold away that auction, and by that money he can also maintain himself. The father all of a sudden stopped not to sell out the that auction. So incident occurred. There was no intention to kill the father, or all of a sudden incident also occurred.
intention ta gather karibo ko type kemti janiba jane ko type ro weapon dharichi ko part ta use karuchi
302 the intention, essential ingredients is intention. If there is intention is lacking, cannot be a case out of section 302.
302 khali intention asila ba kicha bachhiba
Mainly the intention.
When a case would fall under section 302, when culpable homicide will come in the murder category.
Yes.
When? Where culpable homicide is defined.
Amounts to murder. Amounts to murder.
Culpable homicide is defined where? In which section?
300, 299, 300.
Culpable homicide is defined in which section of the Indian Penal Code?
299.
299. When culpable homicide will amount to murder, in which section it is stated? and when it will not amount.
304 part B.
We are asking you a pertinent question. When the culpable homicide will amount to murder, when it will not amount to murder. It will amount to murder when it will come under those 4 clauses which are there under section 300.
300.
If it comes under 5 exceptions which are provided under section 300, then it would go to either 304 part 1 or part 2. So here you are trying to bring it under that exception clause, that on the spur of the moment, incident occur. But that is one side. But the question is, if you come to that particular aspect of the exception, just see that exception. If there are in this type of cases, which exception according to you would be applicable? Whether it would be exception 1 or exception 4 to section 300 or no exception.
Exception 4 3 of 300.
Achha, exception. Exception 4 to culpable homicide is not murder if it is committed without premeditation in a sudden fight, in a heat of passion, upon sudden quarrel, and without the offender having taken undue advantage or acted in a cruel or unusual manner.
Here is the same similar case.
Sudden quarrel heithibo.
There was no quarrel here.
Then how it will come under exception 4? गोटे कड़ी झगड़ा होउची तारी भितरे हठात कि गोटे रागी किनी गोटे पहार देला, so that would come under exception 4. If there is no quarrel, what is the question of exception 4?
Only allegations are only allegation when he wanted to show his auction that has been checked by the father. They didn't allow to show that auction.
Come to section exception 1. Exception 1 Kochi, culpable homicide is not murder if the offender, whilst deprived of the power of self-control, by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident. So, being deprived of the power of self-control by grave and sudden provocation, if you say that, let us analyze it. So this above exception is subject to the following proviso, that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. Secondly, that the provocation is not given by anything done in obedience to law, it is not be attracted. That the provocation is not given by anything done in exercise of private defense, it is not applicable. So the first exception is that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person.
Yes.
Let us say, ଆପଣ କାହା ଘର ପାଖକୁ ଗଲେ, ଘର ପାଖକୁ ଯାଇକିନି ତାକୁ ଇଆଡୁ ସିଆଡୁ ଗାଳି ଫଜିତ କଲେ, ସିଏ ସେଇଠୁ ଆସିକିନି ଆପଣଙ୍କୁ ଅପୋଜ କଲା ପରେ ଆପଣ ତାକୁ ଆଟାକ୍ କଲେ, ଆପଣ କହିପାରିବେନି ଯେ ଏଇଟା ମାନେ it is not that this provocation, it cannot be said that it is voluntarily provoked by the offender. So এটা ଆପଣଙ୍କର ଫଲ୍ଟ ରହୁଛି, ଆପଣ ଯାଇକିନି ତା ଘର ପାଖରେ, ଏଠି କଣ ହେଇଛି ନା ସିଏ ବଳଦ ନେଇକିନି ଯାଉଛି ବିକି ଦବା, ବାପାଟା କହୁଛି ନାଇଁ ବଳଦ ବିକିନି, ରାଇଟ୍? ତ ଏଇ ସର୍କମଷ୍ଟାନ୍ସ ରେ ଆପଣ ବାପାକୁ ଟାଙ୍ଗିଆରେ ମାରିଛନ୍ତି, even if after he fell down also, you have not stopped. You have went on dealing blows after blows. ନଅଟା ଚୋଟ ଆପଣ ବାପାକୁ ଦେଇଛନ୍ତି ତା ଦେହରୁ maximum number of blows are on the head. ତେଣୁ ଏଠି ଯୋଉ ଆପଣ କହୁଛନ୍ତି ଯେ let us say you are deprived of the power of self control ଯେ ବାପା କାହିଁକି ଅଟକେଇଲା ମୁଁ ତ ନେଇକି ଯାଉଥିଲି ବଳଦଟାକୁ ବିକି ଦବା ପାଇଁ ବାପା ମତେ ଯେହେତୁ ଅଟକେଇଲା ସେଇଟା ମତେ ମୁଁ ସେଲ୍ଫ କଣ୍ଟ୍ରୋଲ ମୁଁ ଲୁଜ କଲି ତେଣୁ ସେଇ ସେଲ୍ଫ କଣ୍ଟ୍ରୋଲ ଲୁଜ କରିବା ଦ୍ୱାରା ମୁଁ ବାପାକୁ ମାରିଲି so can it come within this exception 1
Maybe
exception 4 ରେ ଆପଣଙ୍କର ଆସିବ ନାହିଁ
exception 1, sir.
exception 1 ରେ କେମିତି ଆସିବ କୁହନ୍ତୁ
Because he was in hungry. He does not have any money. So wanted to sell out that bullock, and out of that money he can also maintain himself as well as his family.
Mr. Counsel, where is the evidence to that effect? ଆପଣ ଯୋଉ ଜିନିଷ ଆପଣଙ୍କର କିଛି ଆଣିଛନ୍ତି evidence ରୁ ସେ hungry ଥିଲା ସେ ଏମିତି ନେଇକି ଯାଉଥିଲା ତାକୁ ଏଇ ଯୋଉ ଜିନିଷଟା ବଳଦ ନେଇକି ଯାଉଥିଲା ଏଇଟା କେବଳ ଏତଲାରେ ମଧ୍ୟ ଅଛି
Accused statement.
accused statement ରେ କଣ କହିଛନ୍ତି ଆପଣ ଆପଣ accused statement ରେ କଣ କହିଛନ୍ତି ଆପଣ ବା କହିଛନ୍ତି ମିଛରେ ମୋର ଜମି ବାଡି ଖାଇବା ଲାଗି ମୋର ଭାଇ ଦାଦା ପଇସା ଦେଇ ସାକ୍ଷୀ ଆଣି ଏମିତି ମିଛ କହୁଛନ୍ତି ଏଇଟା ହଉଛି ଆପଣଙ୍କର accused statement କୋଉଠି ଆପଣ ଭୋକିଲା ଥିଲେ ଗାଈକି ନେଇ ଯାଉଥିଲେ ବିକିବା ପାଇଁ ବଳଦକୁ ବାପା ଅଟକେଇଲା ସେଇଥିପାଇଁ ଆପଣଙ୍କର ରାଗ ହେଲା ଆପଣ ବାପାକୁ ଇଏ କଲେ କାହାର cross examination accused of cross examination accused ଯୋଉ ସାକ୍ଷୀ ଦେଇଛି
91, page 91.
ହଁ
I together with my family.
କିଏ ରୁହନ୍ତୁ DW1 କିଏ
The
accused himself
Sir, page 91.
ଆଚ୍ଛା ଆପଣ କେସ୍ କଣ ପଢୁନାହାନ୍ତି ଆପଣ chief examination ଟା ପଢ
I am the accused in this case. On 25/6/2009, 5:30 am, I have never inflicted any blows on the head, back, and other portion of my father by means of candia. My father died out of the vehicular accident on.
ଦେଖୁଛନ୍ତି ଆପଣ କଣ ପ୍ଲି ନେଇଛନ୍ତି ଆପଣ ଗୋଟେ କଥା କହୁଛନ୍ତି ଆପଣ ଏଠି ପ୍ଲି ନେଇଛନ୍ତି ମୋ ବାପାକୁ ଗାଡି ଧକ୍କାରେ ମରିଗଲା
That was before that. 25 they are now.
ଏବଂ 25/6 ତାକୁ ନେଇକିନି ଗାଡି ଧକ୍କା ଯୋଗୁ ତାକୁ ନେଇକିନି ଗଲେ ଫୁଲବାଣୀ ହସ୍ପିଟାଲକୁ ମୋ ଭାଇ ଆଉ କାକା କମାଣ୍ଡର ଜିପ ରେ ତା ଚିକିତ୍ସା ପାଇଁ ଆଉ ସେଇ and ତାପରେ ସେ ତାକୁ SCB କୁ ମେଡିକାଲ କଲେଜ କୁ ରେଫର କରାଗଲା ସେଇଥିପାଇଁ ଏଇ ଯୋଉ କେସଟା ହେଇଛି ମତେ ମିଛରେ ମୋ ଭାଇ ଆଉ ମୋ କାକା in order to grab my land they have this is your being you yourself volunteered to be a witness on your side that is DW1 so this is your case ଆଉ ଏଇ ଯୋଉ କଣ ଭୋକିଲା ଥିଲା ନେଇ ଯାଉଥିଲା ବାପା ଅଟକେଇଲା ଏ ତ କିଛି ନାହିଁ ଆପଣ ତ ଗାଡି ଧକ୍କା ଆଡକୁ ପଳେଇଲେଣି ପୁରା ଟୋଟାଲି ଏଭଳିଆ ପ୍ଲି ନବା ପୂର୍ବରୁ ଆଟଲିଷ୍ଟ ଦେଖିବାର ଥିଲା ନା ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟରେ କଣ କୁହାଯାଇଛି ସେତେବେଳକୁ ପୋଷ୍ଟମର୍ଟମ ରିପୋର୍ଟ ଆସି ଡାକ୍ତର ଦେଖି ଗଲାଣି ଯୋଉଟାକ ସବୁତକ ଇନସାଇଡ ରେ ମୁଣ୍ଡରେ ଆପଣଙ୍କର ଛୋଟ ପରେ ଛୋଟ ଦିଆ ହେଇଛି ତାପରେ ଡେଥ ହେଇଛି ଆପଣ କହୁଛନ୍ତି କଣ ନା ଗାଡି ଧକ୍କାରେ ମୋ ବାପା ମରିଗଲା
Para 4. Cross-examination para 4. By the period of death of my father, towards the cultivation season and cultivation operation were being carried in the lands of landowners. It is not a fact that on 25/6/2009, I was taking my block in the morning to sell out. It is a false to say that my father on the morning tried to restrain me from selling my block. It is not a fact that on that morning I was taking my block around 5 a.m. in order to sell passing through the frontal of Mirandipa, the and that at that time I was carrying a tangia. It is not a fact that at that time when my father restraining me tried to take away the block from me, at that time I became enraged, dealt tangia blow on the head, back.
ହେଲା prosecution case obviously ସେ suggest କରିଛନ୍ତି prosecutor ର duty ହଉଛି ଆପଣଙ୍କର ଯେହେତୁ ମାନେ defense ହିସାବରେ ନିଜକୁ examine କଲେ ଏବଂ ଗାଡି ଧକ୍କା ଆଡକୁ ଗଲେ ତେଣୁ prosecutor ଯେତେବେଳେ ଆପଣଙ୍କୁ ଜେରା କଲା ସେ obviously prosecution case ର suggest କରିବ ଯେ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ଗାଡି ଧକ୍କାରେ ଆପଣଙ୍କର ବାପା ମରିଛି ସେଟା ଠିକ ନୁହେଁ ଘଟଣାଟା ଏଇଭଳି ଭାବରେ ହେଇଛି ତ ଠିକ suggest କରିଛନ୍ତି ତ ଆପଣ that is his duty, he has done it ଏବଂ ଆପଣଙ୍କର ଯୋଉ ଗାଡି ଧକ୍କାଟାକୁ ସେ dispute ମଧ୍ୟ କରିଛନ୍ତି ହେଲା ବଳଦ ତ ଆପଣଙ୍କର କେସ୍ ନୁହେଁ ଯେ ବଳଦଟା ଆପଣ ନିଜ ପଇସାରେ ରୋଜଗାର କରିକିନି ବଳଦଟାକୁ ଆଣିଥିଲେ
No, that is the evidence that all the brothers they have got their separate block and separate cow. That is evidence is there.
କାହିଁ
What is there?
ଦେଖୁନାହାନ୍ତି
PW5, the cross examination. I have not personally seen the infliction of tangia blow on the person of my father by the accused. When Birendip so informed me about the incident at that time, one Chaturbuja Pradhan, Sushil Pradhan, Rajendra Pradhan, it is were present there. It is a fact that by the time of my arrival near my father at the spot at that time, none else were present near him. Virendipa did not accompany with me to the spot, so also the Sudarshan Deva. In our family are partitioned by meets and bounds, and accordingly the individual brothers had got his own pair of bullocks and of cows.
କୋଉଟା କୋଉଠି ପଢୁଛନ୍ତି
PW5, Vigyan Pradhan, in cross examination.
Yes,
Yes,
paragraph 5
page, sir, PW5,
PW5 କୋଉ page
sir, cross examination.
Para 6.
para 6 we all the brothers in our family are partitioned by meets and bounds.
Meets and bounds, and accordingly the individual brothers had got his own pair of bullock of cows, that and cows.
ତ ଏଇ ଜିନିଷଟା ଯଦି ଆସିଲା
Okay.
ତ ଯୋଉ ବୁଲକକୁ ଆପଣ ନେଇକି ଯାଉଥିଲେ ବିକି ଦବା ପାଇଁ
That is his own bullock.
କୋଉଠୁ ପାଇଲେ
According to that is a partition. If you take it away, that is a partition. According to partition, all the brothers they have got their separate bullocks.
ସେଇଟା ତ ସେମିତି କିଛି ନାହିଁ ଯେ ଆପଣ ନେଇକିନି ନିଜ ଭାଗରେ ଯୋଉ ବଳଦ ପଡିଥିଲା ତାକୁ ନେଇକି ଯାଉଥିଲେ ବିକି ଦବା ପାଇଁ
Para 6, sir. Para 6. It is a fact, admit. That by the time of my arrival near my father at the spot, at that time, none else was present near him. Virendipa did not accompany with me to the spot, and so also Sudarshan Dipa, who is there to the 4 days of the incident. Police examination also.
Within 3 to 4 days, and out there the night.
3 to 4 days.
3 to 4 days, yes. 3 to 4 days of the incident. Police examined me. We all, the brothers in our family, are partitioned by meets and bounds, and accordingly, the individual brothers have got his own pair of bullocks and cow.
ଆପଣଙ୍କର ଡିଫେନ୍ସ ପ୍ଲି ହିଁ ନୁହେଁ ଆପଣ ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ବି ସେ କଥା କହିନାହାନ୍ତି ଯେ ଘଟଣା ଦିନ ମୁଁ ନେଇକି ଯାଉଥିଲି ମୋ ନିଜ ବଳଦକୁ ବିକିବାକୁ ଯାଉଥିଲି ଆଉ ବାପା ଅଟକେଇଲେ ଆପଣଙ୍କର କେସ୍ ତ ହଉଛି ବାପା ଟୋଟାଲ ଗାଡି ଧକ୍କାରେ ମରିଗଲେ ଆଉ ଯଦି ଘଟଣା ଜାଗାକୁ ସିନା ଆଇଲେ ଅସୁବିଧା ଇଏ ହବ ପୁରା ବାପାକୁ ନେଇଗଲେ ଗାଡି ଧକ୍କା ସେ ପୁଣି ତା ପୂର୍ବ ଦିନ 25 ତାରିଖ ଦିନ ଗାଡି ଧକ୍କା ହେଲା ତାକୁ ନେଇକି ଗଲେ ଏଠିକି 26 ତାରିଖ ଦିନ ଟୋଟାଲ କିଛି ଘଟଣା ହେଇନି
Sir, para PW5 para 4 sir. What I guess
PW5
5 PW5 page 59 page 59 para 4. What I guess the accused might have committed the above offense out of rage when my father objected him to sell away our bullocks during that particular period, which was cultivation season.
I see guess that is not the evidence, but the suppose let us say your father opposed you that don't sell the vehicle, bullocks,
yes.
And it is a cultivation season. Obviously, Borsa dino June masere ghotona June masere cultivation season, so don't sell. एया जदि कहले आपन को आवर ब्लॉक कहि पेरू हां आ बोल बोल कहि कोन आवर हां तेणु एठी जो टाइप रो आपण कंडक्ट यू सी one blow two blow it's different but the witnesses have seen that your father was lying on the ground PW7 कोची ना
yes.
Lying on the ground and you are giving blows
Yes.
That is the evidence of PW7.
But she PW7 unable to say in which direction.
I noticed that the deceased was lying down, facing downwards. माने मुंह तळु पडिकिनी पडिची and the accused was inflicting टांगिया blows.
On his back.
तेणु and all these total number of blows we have counted and the मुंडरे 1 2 3 4 5 5टा ब्लो मुंडरे खाली रहयो बाकी ता टिके तळु को आसीकिना आउ सब तक ब्लो चेस्ट ए रीजन सब
Sir, in cross examination, PWC cross examination. The last page 65 last. Page 65 last. I do not recollect. I do not recollect as to if I have stated or not before the police that at the relevant time, Biren Dipa raised cry to the effect that Sugyani Taro Bapaku Hani Deuchi Doudo. It is not a fact that I have not stated before the police also while going to the spot. I noticed that the deceased was lying on the ground facing downwards and the accused was inflicting tangia blows on his head. At that when I shouted, the accused immediately ran away with the tangia. By the time of my arrival at the spot, none else had reached near the deceased.
See, Mr. Panda,
Sir.
Apart from the 2 eyewitnesses, whose evidence is corroborated by the medical evidence, there are 3 other witnesses whom the London trial court has also rightly placed reliance that they had seen you escaping from the spot, holding that tangent. That is another important. And the defense plea is without any substance. Defense plea of accident, you have not even suggested to the doctor that doctor whether these injuries are possible by vehicular accident. You have not put any question. So your case that your father sustained an vehicle accident on 25th and she was shifted from one hospital to the other and met with the death, that cannot be accepted. Number two, this eyewitness version. Number three, corroborating medical version. Number four, the corroborative evidence given by the witnesses who have seen you playing the. Now the question is that let us accept whatever the evidence is that he was going to sell the bullocks and the father opposed that it is a cultivation season, don't sell the bullocks. That much your father has stated, obstructed you. So in that, can you say that it has given you a grave and sudden provocation, and to that extent that you can cause such type of injuries to your father when your old father is lying on the ground, and that would come under exception 1. Otherwise, it would not come within, you cannot bring it to either 304 part 1 to the question asuni.
I got the some decisions for
304 part 1 को आनिया कोले अपन को exception भितर न आइले अपन जाई परिबेन on decision आनछन
some decisions
हाँ
where in similar matters where it has been converted to 304 part 2.
part 2 ର ପ୍ରଶ୍ନ କୋଉଠି
ଆଜ୍ଞା
ପୁରା ଲାଇନ ତ part 2 କୁ ଯିବନି
because there are no prior enmity between the father and son.
enmity is not a, whether there is an enmity or not, that is not a criteria for bringing it either to part 1 or part 2. That is nowhere it is stated that somebody should have.
My Lord Justice Behera also delivered a decision here that is reported in 2024. Justice Das.
This one with the kitchen I yet acute judgment. Second judgment होची गोटे रागी किनी गोटे पत्थरटा उठेइकिनी फोपाड़ी देला सेटा हेड रे गला इगुडा कोन आधीर देइछंती this decision no applicable to this. Substantial evidence found. Yes, Mr. Nayak, what do you say?
That was the eyewitness 1, 3, and 7, and as well as the report of the doctor, and the time of occurrence is the morning time, that the month of June 6 10. They are taking the ground that the other time the darkness, it cannot be possible that the month of June morning at 6 a.m. cannot be dark. The 7th, the schedule 7, that ଶୁଣିଲେ ମାରିଦେଲେ ବୋଲି କହିଲେ. That part also the in the judgment, the learned court has deal with the after the coming schedule 7 found that his co-village of the deceased and as an eyewitnesses to the occurrence. According to the schedule 7, on the alleged morning, while he was attending the call of nature at the relevant time, he heard the voice of schedule 1 from the side of schedule 1 house to the effect that Udjani ତା ବାପାକୁ ଆଣି ଦେଇଛି.
The appellant, Sugyan Pradhan, faced trial in the court of Additional Session Judge Board in ST number 75 of 2009 for offences punishable under section 302, 506, 201 of the Indian Penal Code on the accusation that on 26/6/2009 at about 6 a.m. at Mahi Bahal, Harijan Sai, he committed murder of his father, Ramesh Pradhan, and also committed the act of criminal intimidation by threatening the informant, bracket PW1, and his elder son, and also after having reason to believe that evidence that after committing murder of his father, he has concealed the weapon of offense, that is Tangia. The Learned Trial Court by judgment and order dated 30/8/2010 though acquitted the appellant of the charges under section 506 and 201 of the Indian Penal Code, but found him guilty under section 302 of the Indian Penal Code and sentenced him to undergo imprisonment for life and to pay a fine of rupees 5,000 in default to undergo further imprisonment for a period of 2 years. Stop. The prosecution case, as per the first information report lodged by PW1 Biren Deepa before the inspector in charge of both police station on 26/6/2009 is that on that day in the early morning at about 6 a.m., he was present in front of his house and saw the deceased and his son, bracket Ray, appellant, were proceeding with a pair of bullocks. The deceased was following the appellant and prevented the appellant to take the bullocks for which the appellant assaulted the deceased with tangia on the head. After the deceased fell down on the ground, the appellant assaulted on the neck of the deceased. Stop. When PW1 proceeded to interfere, the appellant showed him tangia for which the informant came inside the village and informed about the incident in the house of the deceased. Stop. PW1 and the elder son of the deceased shifted the deceased to Pulwani Hospital, who was in a serious condition, and the appellant fled away from the spot. The oral report of PW1 was reduced to writing by Babuli Kaur, Gramrakhi, attached to both police station, and it was read over to PW1, and PW1 gave his LTI on the report and it was presented before the IAC of both police stations. And accordingly, both PS case number 67 of 2009 was registered on 26/6/2009 under section 324/307 of the Indian Penal Code. PW14, the IIC himself took up investigation of the case after registering the FIR, and during course of investigation he examined the informant bracket PW1 as well as the scribe of the FIR Babuli Kohar bracket PW2 who had accompanied him to the police station. The IO visited the spot and prepared the spot map exhibit 10 and examined other witnesses. He collected bloodstain earth, sample earth in presence of the witnesses and prepared seizure list exhibit 2. He also then examined other witnesses, searched for the appellant, and finally apprehended him from village Charichak and arrested him. While in police custody, the appellant, in presence of the witnesses, disclosed to have thrown the tangia in the water of Lakshmi Nala and also volunteered to give recovery of the same. The statement of the appellant under section 27 of the Evidence Act was recorded by the IO while exhibit 4 and thereafter the appellant led the witnesses and the police party to the Nala, and from the water he brought out the tangia and produced the same before the IO, which was seized as per the seizure list exhibit 3. During course of investigation, PW 14, the IO came to know that Ramesh Pradhan was that the deceased was referred to MKCG Medical College Hospital, Barampur for better treatment. Referred to so and so, and then he sees the wearing apparels of the appellant under seizure list exhibit 6. And on 27/6/2009, the appellant was forwarded to court. Subsequently, more witnesses were examined And on 29/6/2009, the IO came to know that the deceased succumbed to his injuries while undergoing treatment at SCB Medical College Hospital, Cuttack. On receipt of intimation from the SCB Medical College, one UD case was registered at Mangalabag police station and inquest was held. And the dead body was sent for post-mortem examination. And PW12, Assistant Professor, Department of FMT, SCB Medical College Hospital, conducted PM examination and submitted his report by Exhibit 8. I also received the reports from district headquarters hospital where the deceased was treated in an injured condition. The IO then received the UD case record from Mangalabag police station, the inquest report, dead body challan and postmortem report. He took steps in sending the exhibits to SFSL Bhubaneswar, Rasulgarh, Bhubaneswar, for chemical examination and received the chemical examiner's report, Wide Exhibit 15. On completion of investigation, he submitted charge sheet on 15/10/2009 under section 302-201-506 of the Indian Penal Code. After submission of charge sheet, the case was committed to the Court of Session, where the Learning Trial Court framed charges against the appellant. The appellant refuted the charges and pleaded not guilty and claimed to be tried. Accordingly, the sessions trial procedure was resorted to establish his guilt. In order to prove its case, the prosecution examined (14) witnesses. the witness could have a short rate, so we could 1 8 1 is an eyewitness one. The prosecution also proved 15 exhibits. Exhibit would have exhibit 1 is and also proved 3 material objects, MO1A, MO2. The defense plea of the appellant is that on 25/6/2009, the deceased met with a vehicular accident and he was shifted to Pulwani Hospital by his brother and uncle in a jeep, and then he was referred to SCB Medical College Hospital, Cuttack, for treatment. And the case has been falsely instituted against him by his brother and his uncle in order to grab his properties. The appellant examined himself as DW1. The London trial court, after assessing the oral as well as documentary evidence on record, came to hold that the deceased met a homicidal death. The London trial court also accepted the evidence of and also the corroborative evidence which has been adduced by PWs 3, 5, and 6, who have seen the appellant running away from the spot while the deceased was lying in a pool of blood. The London trial court also accepted the prosecution case relating to the leading to discovery of the weapon of offense, that is Stangia, at the instance of the appellant, and came to hold that there is no evidence that for the recovery or giving a statement under Section 27 of the Evidence Act, there was any manner of threat, coercion, or allurement given to the appellant. though the Lennon trial court gave benefit of doubt to the appellant, so far as the commission of offences under section 201 and 506 of the Indian Penal Code are concerned, but came to hold on overall analysis of the evidence that the prosecution has well established the case against the appellant that he committed the murder of the deceased, and accordingly found him guilty under section 302 of the Indian Penal Code. Mr. Niranjan Panda, land counsel for the appellant, argued that PW3 has stated that there was darkness at the relevant time of the occurrence. And he has further stated that he had not seen anyone else near the close vicinity. And therefore, the presence of PW1 at the scene of occurrence is a doubtful feature. And since there was darkness, it would not have been possible on the part of PW1 and PW7 to mark the assault. The Land Council further submits that the factual scenario indicates that the appellant is the son of the deceased, and there was no previous animosity between the two. And the occurrence happened all on a sudden when the appellant was prevented by the deceased to take the bullocks, and therefore, on grave and sudden provocation, the appellant dealt the blows to the deceased by means of tangia, and therefore the case of the appellant would fall within exception 1 to section 300 of the Indian Penal Code, and it would be a case under section 304 part 1 of the Indian Penal Code and not 302. The Land Council further submits that since the appellant has been taken into judicial custody since 2009, after altering the conviction to 304 part 1 of the Indian Penal Code, the sentence be reduced to period already undergone. Mr. Jateshwar Naik, an additional government advocate, on the other hand, supported the impugned judgment and argued that both PW1 and PW7 are the co-villagers of the appellant as well as the deceased. And the occurrence took place at about 6 o'clock in the month of June. And therefore, it cannot be said that there would be any hindrance to the visibility of the occurrence by both the eyewitnesses. He further submits that the evidence of both the eyewitnesses is getting corroboration from the medical evidence adduced by PW12, who has seen number of injuries, not only on the vital part of the body like head, but on the chest, and opined the cause of death to be due to intracranial hemorrhage. The London Council further submits that the London Trial Court has rightly placed reliance on the evidence of PWs 3, 5, and 6, who have lent corroboration to the evidence of the two eyewitnesses and have seen the appellant running away from the spot. The additional evidence against the appellant is that at his instance, the weapon of offense, that is Tangia, was recovered basing on the statement recorded under Section 27 of the Evidence Act. He further argued that it is not a case of grave and sudden provocation, and the deceased merely asked the appellant not to take the bullocks to sale, as it was a cultivation season, and the reaction of the appellant in assaulting the deceased mercilessly, even after he fell down on the ground, lying in the face downwards, and dealing repeated blows on the scalp, shows his intention to commit the murder. Therefore, the London Trial Court has rightly found the appellant guilty under Section 302 of the Indian Penal Code, and the appeal should be dismissed. Adverting to the contention raised by the London Council for the respective parties, let us first analyze the evidence on record as to whether the prosecution has successfully established that the deceased met with a homicidal death or not. Apart from the inquest report Exhibit 5, the doctor bracketed PW12, the assistant professor attached to Department of FMT, SCB Medical College Hospital, who conducted post-mortem examination over the dead body of the deceased on 28/6/2009 has noticed the following external injuries, quoted. And he also noticed the following internal injuries, quoted from page 78, 77 to 79. He has opined, then again you quote it. The doctor has specifically stated that Tangia bracketary axe, Kati, Buzali comes under the category of moderately heavy to heavy weapon. Nothing has been brought out in the cross-examination to disbelieve the evidence of PW12. In view of the inquest report, coupled with the evidence adduced in this case, more particularly the evidence of the doctor, bracketary PW12, who conducted post-mortem examination, and the post-mortem report exhibit 8, we are of the view that the Lennon trial court has rightly came to the conclusion that the deceased met with homicidal death. Coming to the evidence of the eyewitnesses, PW1 Biren Deepa has stated that the occurrence took place in front of his house. On the date of occurrence in the early morning, while he was present in front of his house, he noticed that while the deceased was passing in front of his house, the appellant dealt a blow by means of a tangia on the head. And when he interfered and asked the appellant as to why he was inflicting tangia blows to the deceased, he interfered. And then he rushed to the village and informed the matter to PW5, the son of the deceased. He further stated that he informed the matter at the police station, and one person scribed the FIR, and the deceased was shifted to Fulbani Hospital. In the cross-examination, he has stated that the incident took place at a distance of about 200 cubits ahead of his house, and the incident happened around early dawn on that morning, and he had not marked as to where on the person of the deceased the axe blow hit. He stated that he could not say as to who scribed the report which was presented at the police station. And further stated about the presence of houses near the place of occurrence. Nothing has been brought out in the cross-examination of PW1 to disbelieve his evidence. Stop. PW7 has also stated that in the early morning on 26/6/2009, 9, while he had been to attend the call of nature, he heard the voice of PW1 coming from the side of his house to the effect that the appellant had is dealing blows to the deceased. And hearing such shout, he rushed to the spot, that is to the front of the house of PW1, where he noticed that the deceased was lying down, facing downwards, and the appellant was inflicting Tangia blows. And when he shouted at the appellant, he ran away with the Tangia. He further stated that the appellant inflicted Tangia blows to the deceased as the deceased protested him taking the pair of bullock of the family to sell, despite the time was a cultivable season. In the cross-examination, he has stated that the spot of occurrence would be around 50 to 60 meters away from village locality. And by the time of arrival at the spot, no one else had reached near the deceased. The contention of Mr. Panda referring to the evidence of PW3 is required to be discussed here. PW3 is a witness who has also stated that he had gone to attend the call of nature, and therefrom he witnessed the occurrence that the appellant was inflicting Tangia blows to the deceased in front of the house of PW1. And then the appellant fled away from the spot. In the cross-examination, he has stated that at the relevant point of time, there was slight darkness and he had not seen anybody else near the vicinity. Since PW1 and PW7 are the co-villagers, so also the other witnesses like PW3, PW5 and PW6, in our humble view, in the early morning at about 6 a.m. in the month of June, there would not have been any difficulty for the witnesses to mark the assault, to identify the assailant and the deceased, and also the manner of assault. The witnesses are at different places and watching the occurrence, and one might not be seeing the other, and therefore the statement which has been made by PW3 does not rule out the presence of PW1 or PW7 at the spot to have noticed the occurrence as the appellant assaulted to the deceased. The other witnesses' evidence are equally important, like PW5 and PW6. PW5 has stated that when PW1 came to his house and informed that the appellant had inflicted tangia blows to his father, bracketed deceased, he rushed to the spot and found the deceased lying in a pool of blood in front of the house of PW1, and there were cut injuries on the neck and backside of the head and on his back. Whereafter the deceased was shifted to Fulbani Hospital. PW6 has also stated, Susila Pradhan has also stated that hearing halla raised by PW1 from the side of his house, he rushed to the place and found the deceased lying in a pool of blood in front of the house of PW1, and the accused, being armed with a tangia, was running away towards the culvert of the village. And he found that the deceased was lying on the ground facing downwards, having cut injuries on the back portion of the head, scapula of his back, and struggling for the life. And then he was shifted to Fulbani Hospital. The conduct of the appellant from escaping from the scene of occurrence holding tangia is very relevant under Section 8 of the Evidence Act. In view of the evidence of all these witnesses as discussed above, it appears that the prosecution has proved that the occurrence in question took place in front of the house of PW1. The manner of assault as deposed to by manner of assault on the deceased as deposed to by PW1 and PW7 is getting corroboration from the evidence of the doctor, bracket PW12, and from his post-mortem report findings. In addition to that, the evidence of the witnesses that the appellant was seen decamping from the spot holding the weapon of offense is also a factor which strengthens the prosecution case. The evidence of the IO that while in police custody, the appellant volunteered to give recovery of the weapon of offense, and accordingly his statement was recorded, and he led the witnesses and the police party to the wet water from where he brought out the tangia and produced the same before him, and accordingly the seizure list exhibit 3 was prepared, is a factor which the London trial court has rightly placed reliance on it. Therefore, from the aforesaid evidence of eyewitnesses and witnesses to the circumstances of the appellant running away from the spot holding weapon, coupled with the medical evidence, we are of the view that the prosecution has proved that it is due to the repeated blows by means of tangia given by the appellant, that resulted the death of the deceased. Stop. Now coming to the next contention raised by the London Council for the appellant, whether the case would fall within the ambit of exception 1 to section 300, and the case would be covered under 304, or would be one under section 304 part 1 of the Indian Penal Code. Culpable homicide, which has been defined under section 299 of the Indian Penal Code, is murder when it comes under the 4 clauses that is mentioned under section 300. So far as exception 4 is concerned, the culpable homicide is not murder if it is committed without premeditation in a sudden fight, in the heat of passion, upon a sudden quarrel, and without the offender taking undue advantage or acted in a cruel or unusual manner. However, in this case, there is lack of evidence that there was any sudden quarrel or sudden fight between the parties. Therefore, we are of the view that exception 4 could not be applicable in the case. Coming to the exception 1, it is stated that culpable homicide is not murder if the offender, whilst deprived of the power of self-control by grave and sudden provocation, causes the death of the person who gave the provocation, or causes the death of any other person by mistake or accident. This exception 1 is subject to certain provisos, and so far as the first proviso to exception 1 is concerned, it is stated that the provocation is not sought or voluntarily provoked by the offender as an excuse for killing or doing harm to any person. In the case in hand, as it appears that since it was a cultivable season, the deceased asked the appellant not to take the bullocks for the purpose of selling. And though PW1 has PW5 has stated, PW5, the brother of the appellant, has stated in the cross-examination that all the brothers in their family are partitioned by meets and bounds, and accordingly, the individual brothers has got their own pair of bullocks and cows, but no such plea has been taken by the appellant that he was going to sell his own cows, to which the deceased father prevented. Rather, he has taken a plea that his father met with a vehicular accident and shifted to the hospital and died during course of treatment. Even though such a plea has been taken by the appellant being examined as DW1, but no such suggestion has been given to the doctor PW12 who conducted postmortem examination that the injuries which are noticed by him on the deceased are possible by vehicular accident. Therefore, the defense plea is totally not acceptable. Moreover, when the appellant was examined under section 313 CRPC, he has not taken any such plea that the deceased met with vehicular accident for which he was shifted to the hospital and died. Therefore, whatever the appellant has deposed as DW1 seems to be an afterthought one. Coming to the factual scenario, we are of the view that it cannot be said to be a case of grave and sudden provocation on the part of the appellant to lose his power of self-control and dealt blows after blows on his father. The manner in which the assault has been made and the number of injuries that are noticed by the doctor on the scalp itself shows that the assault was made on a vital part of the body, which has resulted in causing fracture of the skull and leading to hemorrhage. And the sharp side of the tangia has been used to cause the injuries, and the doctor has stated that the external injuries number 1 and 2 and the corresponding internal injuries are fatal in ordinary course of nature to cause death. Therefore, we are of the view that the case squarely comes under the ambit of section 302 of the Indian Penal Code, and the London Trial Court has rightly found the appellant guilty under such offense. In view of the foregoing discussions, we are of the view that the jail criminal appeal being devoid of merit stands dismissed. Put a note of appreciation on the London Council for the appellant, so also the London Council for the respondent. Are you being awarded this amicus curiae or
No.
so jail criminal legal aid? So you will get the fees from the legal aid.